intelligence, Lord. For complying with the office objections, Lord, the matter came, and my Lord, a conditional order was passed in the day. And Lord, I filed an application to recall that order. My Lord, you will also kindly post this matter for tomorrow or day after. For complying with the office objections, Lord, the same was not complied. In the meantime, a conditional order was passed.
So it is dismissed. You are moving restoration.
Yeah, please.
25th.
Please.
Lords had given a date on the 12th of this month. Was it listed with a serious urgency, my lord? Because there's I've challenged the order of the learned civil judge. They're making frantic efforts to change the revenue entry. Maybe had on Monday, my lord.
When it is going to be posted? Next date is?
No, this is a fresh matter.
Fresh matter.
Fresh matter.
Then on 4th of April.
But that's emergency. It's emergency. They're making frantic efforts to change the revenue entries.
Yes.
4th of 33.
33. Oh. Why? Why? Therefore, then let it go to 11th of June.
Which one?
As requested by law.
That's also due to excessive noise pollution created by the power loom industry. Even after the permissible limits within the day, they're running power loom industries. The PIL managed to stop that. They filed a writ petition, manage, and it was because it was in the nature of PIL. We have been directed to PIL, fresh matter. There's urgency in the matter.
No, it will come after you remove the office.
Lords, fresh matter, my lords, and challenge the order passed by the Honorable Commercial Court, my lords. I've challenged the application.
Which court?
Honorable Commercial Court, my lords. Trial Court, Honorable Trial Court, my lords. I challenge the application filed by the respondent, which is filed under 58 of BNS Act, my lords. 58 of BNS Act.
Little louder.
58 of BNS Act, my lords. That is mark the secondary document, mark the BNS. Lords.
What is BNS?
Bharatiya Nyayatya Sannitha, my lords.
So what do you want?
My lords, I'm challenging the said application, my lords. If at all the document is marked, in regard to as a secondary evidence, the entire case would be jeopardy, my lords.
Once you remove the office and release it. No, not by mail. Yes.
Lordship, one matter as a public interest litigation, your lordship, where under the housing scheme of the Rajiv Gandhi housing scheme, your lordship, sites are allotted, your lordship. I have filed in the petition already. Notice has been ordered by this honorable court. In the house sightings has been allotted, your lordship, kith and kin of the politicians as well as those who are holding the properties. That against that I have filed the petition, your lordship. Now, some of them, your lordship, during the constructions, your lordship, the urgency in this matter because of the lordship, the whole purpose of the schemes which was made, your lordship, that has been deviated and it has been made use of this. Hence, your lordship, a matter for consideration, your lordship, at.
Pardon?
Hence, the matter for consideration, your lordship, at the.
Consider when it is posted.
No, because your lordship, now it is there. South sides has been allotted to the kith and kins of the politicians.
When
Those who are having the properties already in their name.
When it is posted, we'll consider. Yes. Pardon?
Appellate for the fresh petition, Your Honor, the IA on hearing on IA stay application.
IA for? IA for? Stay application. So what is the urgency?
Date is the 21. Execution date is the 21.
27. You can take time in execution. Yes. Yes, madam. Not. So what?
May be permitted for the petition because the subject matter was survey and the survey report. Both have been reconsidered by the learned report and a fresh report has been submitted. In that light,
101 learned advocate Ms. So stated that the subject matter of the present contempt petition is reconsidered. Please listen. Reconsidered by the trial court. Subject matter is reconsidered by the trial court, and the press report is already submitted. In that view, petitioner seeks permission to withdraw the present contempt petition as not served away. Full stop. Also submitted on record is memo dated 19/3/25, signed by learned petitioner. seeking withdrawal of the petition. Paragraph. The request is granted, the petition is dismissed as withdrawn.
Lordship, the writ appeal arising out of the learned civil judge's order. We are for the APMC minority. The learned civil judge had ordered us to give a shop to a allottee who doesn't have licenses to trade in the market area. So he's filing contempt against us for not giving that, but the writ appeal is pending, my lord.
Let him file the contempt.
Any date can be given, even 1 week, 2 weeks later also.
You remove the office of this.
Oh, removed, my lord.
Then where is the question of, it will come within one week, yes. Yes, Mr.
Let's serial number 50 minutes. Serial number 50 minutes.
60,
50, 50.
50.
Let's appear for accused minutes. 2 weeks time minutes to file reply minutes. I have
12th
informed the
June.
other side. Minutes.
12th June.
Oh, that's okay.
Serial number 44, please, my lord.
Yes, madam. You want to mention? Yes,
But serial number 44, please, my lord. I have informed the other side.
40.
44, please, my lord. There's some inconvenience.
I appear for R6, my lord.
It is regarding what? 2017 PAL.
Please, my lord.
It is regarding what?
Lord, it is regarding public road, please, my lord.
Let it be called out.
Lord, the senior, there's some personal inconvenience today, please, my lord. Any date, my lord, next week.
You are
my
there.
lord. Lord,
You are there.
Lord.
Lordship, kindly.
4th of April.
Grateful.
My lord, in this matter,
fourth, there's some difficulty.
We are the NBFC, lordship. The police is arresting because we are registered under the RBI, my lord.
Pardon?
Yeah, this microfinance audience has been followed, my lord. We are the NBFC and registered under the RBI. Police has already registered more than 8 FIR without going to.
Not able to understand anything what.
My lord, this is my.
Come on the mic.
This is a microfinance ordinance, my lord. This petition is the NBFC. Without looking to the ordinance, the police has registered illegal affairs and more than 8 affairs has been registered and the officials have been arrested, your lordship. The hence we have given this representation to DG and IG as well as the chief officers, my lord. Hence this is a fresh matter. Kindly put up on next week, your lordship.
After removal of office of yours.
My lord, please, next week, any date, my lord.
No, sorry. Yes.
Your Honor, I'm for the petitioner and there is a appeal from commercial court. The commercial court had dismissed the case because of technical grounds. So we are challenging the same, Your Honor. So
After you remove the officer, not by memo. Yes.
My lord,
My lords, I am appearing for a group of patients who are residents of Shivajinagar, my lords. Because of the Ramzan Mela, the ambulances cannot be access to the patients, my lords. And the footpath is totally been covered and the law and order is out of hands. And
The police authority.
so, my lords,
Mention before the police authority.
my lord, I have filed a PIL, my
Law
lords.
and order, we are not concerned with law and order. In your area, what do you want?
My lords, just I want the ambulance to reach my home, my lords. Be a group of dialysis patients, my lord, who are before this court.
Nothing can be considered in such a manner. Or
my lord, appear for the petitioner in.
what do you want ultimately?
Well, it's just I
Come to
want
the point.
I want just the movement of the ambulance to reach my home and my lord.
There is no system of making any oral submission and oral request and granting oral relief.
My lord, appear for the petitioner
You
in.
do whatever procedure requires, you do it.
My lord,
You can't seek a oral relief by
No,
mentioning.
my lords, I have filed a PIL and let it be taken before the court, my lords.
Pardon?
I have filed a PIL, my lords, a group of patients.
There. It will be listed once you have filed.
Yes, my lords. It's an urgency matter because of the Ramzan itself, my lords. In this 15 days only, all this.
Listed on 25th. 25th, yes.
my lord, appear for the
Yes, Mr.
petitioner in.
Yes.
My lord, appellant in serial number 36, my lord. I have
36.
to file an IA for production of additional documents. So I'm seeking 2 weeks adjournment, my lord.
It will go beyond because 18th of June, as requested by learner of the appellate.
Please, my lord.
Yes.
My lord, appear for the petitioner.
Yes.
In serial number 79 and 79.1.
29, yes.
My lord, the contempt is arising out of the order passed by my lord, the Honorable Justice M.I. Arun. Therefore, this matter has to go before some other.
Contempt can be taken even if. the
Contempt
court
and
has-
also an appeal is tagged with this.
Appeal also,
Appeal also is tagged with this.
not to be placed, 79 and 79.1. 79 only, not to be placed before the court, before the bench where one of us into it.
May I
Yes.
Much
M.I. Arun,
request-
Brigade is a member.
Is your lordship serial number?
this writ appeal is pertaining to the KTPCL Act, my lords. The writ petition was dismissed only on the ground of limitation. Aggrieved by that order, the petitioner petitioners have come in the writ appeal hearing. The matter was listed twice. My lord, date was given. In fact, today a date was given, but it's not listed, my lords. It may kindly be heard at the.
Date is given and not listed, and list it on heard of April. If date is given, it will not be listed. If any date is given, it
If
will
the
not,
date was
it
given,
will remain the same date. Unless you file an application. If date is not given, it will be listed.
Lordship, serial number 64, I'm seeking on serial number 64.
64. yes.
Please, I'm seeking on adjournment, my lords. They have filed their complaints affidavit. I need to verify whether they have complained. That's why I'm seeking on short
You
accommodation.
are for respondent?
I'm for the complainant. BBMP is the respondent.
You are for complainant.
Please,
So compliance affidavit is filed.
they have filed their complaints affidavit, but I'm not sure whether they have. Lordship, because they have to
You
remove.
are not sure, how can be sure in granting the time?
Lordship, I want
Not
to-
granting.
The counsel on record is also not in town, my lords.
Who?
My colleague.
That's the slowly reason, true reason comes
On short accommodation.
whole life.
Tasif, kindly, my lord. May I make one
Fourth
submission?
of it.
Serial number 24, my lord.
24 years.
24. I'm on a pilgrimage tour. Whatever date convenient time for the appellant. Any date convenient to the court. Serial number 24, my lord. Writ appeals.
After vacation,
Much. I'm grateful.
19th of June. As
Much.
requested by learned review of the appellant, appearing through video conferencing. 19th of June. Yes.
Any mention? Further mention? And permissions. Seal number 1. Ashok Bani Dinli.
For seventh respondent.
Yes, my lord. For second and third respondent. Yesterday they have some. The case, my lord, yesterday.
Yes.
My lord, they have submitted the impeding application and also the affidavit, my lord. I wanted to file my reply to this, my lord. Because
This
my
is
lord,
where the tender has already been, work order has been given for the medical
Lord,
mobile unit.
my lord,
my
the
lord.
tender is given to a person for whom earlier there was already a notice saying that he has not been performing, my lord. I got a RTA reply also. I'll submit everything before this honorable court, my lord.
It is a separate cause.
This matter is with respect to the poor construction workers, my lord. Lots of money has been wasted in this particular department. 2023-24, they have spent around 1,041 crores on these people. I will have to really check on all these things, my lord. There is a huge corruption according to me. We'll have to really go deep into this and then check this, my lord. Even this Blossom was earlier, he was also there in as an NGO, and then now he has participated individually as an other hospital. But earlier there was allegations about against him saying that okay, he has not performed. There were already 3 show cause notices were issued against him, my lord. So I'm just getting all those details, my lord. I need some time to make my submissions, my lord.
Yes, what is the order?
The order is-
Let us,
What?
page 50.
Page 50, liberty is granted.
What is the order?
My lord, in this the order, the reason submitted by the learned counsel that the cabinet had not approved is a matter of record.
We are on the operative part. Operative part of the order.
The petition stands rejected. Interim order, if any of any kind subsisting as on date would stand dissolved. The petitioner has at liberty to participate in fresh tender issued or to be issued by the respondents. If the tender is issued or to be issued, it is for the respondents to take its logical conclusion, my lord. See, in this, what happened, my lord, like when the fresh tenders are issued, they increase the financial threshold so that the NGOs don't participate in this, my lord. See, this is the same, they have awarded to a person
for whom they've already issued 3 show cause notice saying that, okay, he is not performing, my lord. So there is some kind of a high level corruption involved in this, my lord. I just wanted to go deep into it, please.
On such general assertions, the appeal which has become infectious cannot be revived.
No, my lord, like, he has not started the work, my lord. That is what is
No, no.
Completed, my lord.
no. The tender, even earlier also the tender process was over, my lord.
We are in appeal. If some developments have taken place, which according to you, some illegality is there, you file asperse procedure. But this appeal will not survive. We will not prevent you from filing any proceedings you like.
No, but this
Bill will
is not as per law, my lord, because they say that the cabinet approval was required for this, but whereas it is approved even in the assembly itself, my lord. When it was approved in the assembly, where is the question of cabinet approval comes, my lord?
But then now things are over. You participated in the press tender.
They
No,
have
my
not
lord,
participated. He has not
We
even
are not,
participated.
see, because they increased the financial threshold, we were not able to
Then
positive base, my lord.
If in your view, the
The-
condition is
so my
imposed
lord,
to
that-
oust you from the tender process, or that the press tender is some illegality, file a press petition.
There was, see,
We are in appeal, not in petition where you can seek amendment.
the letter and spirit of the order of the writ petition is not followed, my lord. Saying that, okay, we were supposed to allow to participate in that. If you are not qualified in that, it is okay, my lord. But they've increased, they changed the whole process, my lord. This is a matter of poor construction workers, my lord. If this lordship can give some time for this to save these this kind of activities, that will save a lot, my lord.
Not possible to give time in a matter which is not surviving. The appellants are the original petitioners who in the writ petition called in question the order of cancellation of tender dated 14/2/22. They prayed for consequential direction for issuance of writ of mandamus to award the contract in terms of the tender in which the petitioner had participated. The tender was plotted in respect of the equipments and manpower for the mobile health clinic project announced by the state government. Full stop. Learn a single judge. Paragraph. Reasons recorded in the petition. In the order, dismiss the petition. The petitioners were permitted to participate in the press tender process. Full stop. Learned single judge observed in the order that a press tender notification was already issued.
No, it was.
After.
It was
After this,
cancelled
What is page 11? Paragraph 11.
Paragraph 11, my lords.
of the affidavit, man.
That is, my lords, the earlier
Um,
tender, which was
Question not-
is
to be issued.
Is to be issued, my lords.
This exercise, the standard notification is issued. Interjection of the court has led to the interim order operating.
In the background of the petitions were put at liberty to participate in the press tender issued or to be issued by the respondents. It was further observed by a single judge that the press tender may be taken into its logical conclusion. Full stop. In the background, the operative facts were that in the impugned tender process, the petitioner was never declared as the lowest bidder. And that before the tender process would conclude in its material stages, exercising right, the tendering authority cancel the tender. Full stop. Ultimately, the aforesaid order was passed by a single judge. It is against the said order. The present appeal is filed. Full stop. When the appeal comes up for consideration, paragraph, the respondents have acted upon in issuing the press tender. Full stop. The impleading applicant. the-
R7,
the
my lord,
impleading-
says.
The impleading respondent who was impleted by order dated 18/3/25 has filed affidavit.
Lord, sorry,
Nimsham.
it is 2 and 3 who has filed their affidavit.
No, no,
I filed the impleading application with the document of work order.
affidavit. In which it is, in which certain facts and subsequent developments are stated and placed on record, in respect to which there is no dispute, there is no factual dispute. Paragraph. It is stated 1, 2, 3, 4. It is full stop. 1, subsequent to the dismissal of the writ petition, press tender notification date 2/3/2024 has been issued by the Karnataka State Building and other construction works welfare board for supply and delivery of 100 numbers of mobile medical units vehicles across the state. 2, the board has issued another notification dated 7/3/24 for selection of agency for operating and managing hundreds smart mobile medical units and preventive health checkup. 3, after the issuance of the aforesaid tender notifications, tenders have been submitted by various entities. Next, the tender of Messrs. Burma Automobiles Limited for supply of delivery of 100 members of mobile medical unit has been accepted, and the purchase order, public work order dated 13/6/24 is issued. Next, work order dated 21/6/24 in favor of Messrs. Soba Renaissance Information Technology Private Limited for supply and installation of the equipments is issued. Next, 1, 2, 3, 4, 5. Work order dated 12/8/24 is issued in favor of the impleading applicant dash Messrs. Blossom Multi-Speciality Hospital, which is selected as an agency for operating and managing 100 smart 100 smart 100 smart mobile medical units and the preventive health checkup. It is given out, paragraph after regular, it is given out in course of the hearing that the petitioner opted out of participating in the press tender process. From although it is sought to be submitted by learned senior advocate Mr. So and so the petitioner, that the petitioner was outstayed of the eligibility clause in the press tender. Full stop. Be that as it may. Paragraph. In view of the above subsequent developments of issuance of press tender and the work order, public purchase order having been issued to the bidding parties, no further adjudication survives in the present appeal, since it has become infructuous, in any case, academic. Full stop. The court would not go into the infructuous subject matter, nor would undertake the adjudication of a controversy which is academic in nature. Paragraph. While learned advocate for the appellant submitted about the alleged while sought to assail about the legality of the press tender process, in any view, the subsequent development and the issuance of press tender notice, etc., will give a fresh cause of action to the appellant. Full stop. The appellant is not prevented to take recourse, if permissible in law, to avail any remedy in respect of his grievance which may survive. Full stop. Without expressing any opinion on that count, the present appeal is disposed of as not surviving.
I make one submission. My lord, I'm representing for respondent number 2 and 3, my lord. I have also filed an affidavit, my lord. in that para number 15, I have expressed that the work is also completed. That also.
Where is that?
I have filed.
Beach Milik. Respond number 2. Learner Revoker will respond number 2. Invite attendance of the court to
Page
submit
number
the
5, para number 15.
affidavit dated 18th March 25 is filed, in which paragraph
15.
15,
Para.
in which it is stated
That was also in violation of the KTTP or 12.
that the work order to the successful bidders have been issued and they have completed their work, and the mobile medical units have been formally inaugurated and they have been deployed throughout the state of Karnataka for use of the building and other construction workers and the dependents.
Please.
In view of the disposal of the writ appeal in above terms, none of the interlocutory applications would survive and they stand disposed of accordingly.
Contempt matters, still number 2,
This case,
Ganpati.
Notice returnable on 12th of June.
that's KDB may directed to KDB,
No,
panel advocate.
you want to join KIDB?
No, KDB is joined,
Oh.
that they may directed to take notice. We will serve a copy.
Appearing here, otherwise.
Serial number 3 also same,
Next,
Number 3,
same.
same.
still number 4,
Notice returnable on 16th June. Next,
5,
Lords, in fact, the order has been complied, my lords, in 4
which one?
and 5, my lords. Both of them. Appearing for
Four.
accused number 1,
4 and 5 you complied with.
complied with, my lords. I might be permitted to file compliance affidavit, my lords. It's been complied last evening, if I'm not wrong, my lords.
Right.
Fresh appointment orders have been given, my lords.
So this serial number 5 is relates to the order passed in 2018. Any
2019, my lords. They
good
were-
that you have complied.
Yes.
With regard to 2015 recruitment, my lord. They ought to have recruited from 2015 onwards. That's the regulation.
So they are in
In
serial number 4, the
Yes.
petitioner is appointed as social science teacher.
Social science teacher.
Social science. Where is that order of appointment?
My lords, order English type, translated copies at page 8, my
Appointment order
lords.
is Page 8, R1.
Page 8, R1. Appointment order has been issued. It's dated 18/3, my lords. And the relevant portion is at page 10, my lords, in light of the factors described.
Yes, page 10, yes.
The relevant portion, my lords, page 10, my lords, in light of the factors described in the proposal and criteria.
Social
Wow.
science, yes.
Yes.
Yes, Mr. Counsel, you have succeeded.
We state regularize them from 2015 onwards. I have no complaint. I have no objection.
Pardon?
Because it's 2015 notification, my lord.
Whatever it is.
They were not given weightage. And we approached this honorable court and we have succeeded up to Supreme Court. On the question of weightage, my lord, they have rejected my case. On the question of that, I have taught some other subject and I am not entitled for the social studies.
So you are not satisfied with this order?
I am satisfied, my lord.
So
They
you're,
ought to have given from 2015, my lord.
so you're not satisfied with the order?
I have
Satisfied or not? You tell us.
No, it's not like that. my lord. They ought to have.
No,
From.
no, there is a reason why we are asking. Are you satisfied with the order or not?
Yes.
Satisfied, you're withdrawing. Learned advocate for the respondent renders the compliance affidavit along with which produced is the letter of appointment. Whereby letter of appointment dated 18/3/25, whereby the petitioner is appointed on the post of science, social science.
Social
teacher.
science teacher.
Full stop. Learned in view of the above, learned advocate to the petitioner seeks permission to withdraw the present contempt petition. It is withdrawn, it is disposed of as withdrawn and not surviving. Both same. In the other.
My
matter,
lords,
what
in
is
this
the-
compliance affidavit.
What is the post?
My lords, two posts, my lords, two complaints.
English teacher?
My lords, one is social science again, my lords. in this.
There are two complainants.
Two complainants. First complaint is social science teacher, my lords. The second,
II 3BW, what is that post here?
my lords, that's under the category in which they're selected, my lords. 3B.
So same, 3B.
3B.
Appointed in the
The
category
other
of
one is Kannada.
3B woman, W. In the category of, in the subject ki jagah, in the category of. Say only that much change. And the date of order will be also same. 18/3/20.
It's also complete.
Serial number 58 also.
This was never maintainable, therefore we are asking. You are in contempt in respect of the order of 2018. So good that you are.
Next, there was an endorsement to me. If the Supreme Court succeeds, they pay, whatever the result by the Supreme Court, they will follow that. That was the endorsement issued.
So first is on the post of Kannada, 3A, 3B woman, and first is social science, 2A woman, and second is Kannada, 3A woman.
Serial number 58 also.
58, what is that?
Similar matter, my lords. Similar matter, my lords. In fact, that is also complied, my lords.
Approach the Supreme Court and the Supreme Court held, I am entitled for the waiting.
You want time?
Yes.
My lords, it's already complied, my lords. I've already complied this also.
Yes.
Complied with.
Now, they have issued my letter.
So same order,
Same order, my lords. The
same order. Social
Social
science, C1B.
C1W.
Which was the number? 58.
58, my lords.
58.
5.
Okay. Thank you. Next.
This is number 6.
Much of it.
So Madhukar M. Deshpande.
Notice returnable on 7th of April.
Number 7. Mr. Sundaresh.
Notice returnable on 23rd April.
So number 8. Mr. Naveed Ahmad.
Number 8. Who is number 8?
Naveed Ahmad.
You are there. Notice written on 16th April, 16th of June. Next. Not possible. Not possible. Still not possible. Sorry. Yes, next.
So number 9. Mr. Arvind.
Notice returnable on.
Lords, in this matter,
What is this conversion?
my lords, it has been complied, my lords, serial number 9.
You-
Today, my lords,
You like.
RTCs will be uploaded within 24 hours, my lords. The conversion order had to be removed from the revenue entries, my lords, which was reflecting in front of the complainant's name. Now, the assistant commissioner has approved by this letter, it is in Kannada, my lords. The Tashildar will carry out within 24 hours.
No, we have verified it now. From this, we have verified. No need for you to verify. The only, the directions in respect of it, the contempt is alleged, which contained in the judgment in the order of learned single judge dated 21st September 24, read as under, an operative part, page 16. Full stop. Today, when the contempt petition came up for consideration, learned additional government advocate, Srimati Pramodini Kishan, produced communication dated 18/3/25, addressed to
The Tashildar from
the office of
Assistant Commissioner.
Assistant Commissioner, in which it is given out that the conversion order, which is reflected in the RTC in column number 11, shall
Be
be
removed,
deleted
please.
within
Lords, 48 hours.
48 hours. Full stop.
Be removed, my lords.
Will be deleted. Full stop. Learned in furtherance, learned additional government advocate states that the deletion shall take place within 1 week.
Obliged.
Full stop. In view of the above, the factum of issuance of above communication could not be denied by learned advocate to the petitioner. In view of above, the contempt petition does not survive. it is accordingly disposed of. Has not survived. Yes.
Sir. Seal number 10, sir. PIL.
My lord, I'm applying for petitioner, my lord.
Yes.
I'm challenging the deputy commissioner order, which has passed by my lord in violation of the land grant rule, my lord. Section 28A of the land grant rule, my lord. My lord, I would like to request your lordship to refer the annexure A, my lord. It's page number 47, my lord. Translation copy is page number 50. My lord, here is deputy commissioner has received the application. So last paragraph, my lord,
Page,
where he says that, my lord, the applicant Shri Rupen Patel has submitted the
which page?
page number 50, my lord.
50, yes.
Last paragraph, my lord, the applicant Shri Rupen Patel has submitted the requisition under the reference 4, requesting to change the path of B Karab land of canal, my lord. So B Karab path is government land, and they are asking to change the path of canal, my lord. Whereas based on this request, deputy commissioner has passed the order, my lord, to change the canal, sorry, not change.
The water is flowing from the canal
Yes, my lord.
right now.
Yeah. No, not right now. Now they have changed the canal. They have given the order to
It's a constructed canal or man or natural canal?
natural canal.
Natural canal.
Natural.
So
That's why it's a big carbon. So deputy commissioner has passed the order, my lord. Totally, it is 24 quintas, my lord. So
where is that order?
in page number 51, my lord, he has confirmed in line 6, my lord, totally 24 quintas of land is converted. He has followed the all regulation, like he has got a report from the assistant commissioner.
That path of the land canal is changed for what purpose?
My lord,
The course of canal is changed, altered.
yes, my lord.
For what purpose?
Purpose based on this request, my lord, based on the request of the Rupen Patel, he is a developer, my lord.
For what purpose?
Maybe it may be for the construction purpose.
Construction.
So my lord,
If the
My
water
lord, the
course,
order is dated 7/2/2019. I don't know what has happened.
my lord, I'm not questioning here my rights, my lord. It is my constitutional duties to discharging.
My
So
lord,
limitation may not, my lord.
water course is changed
Yes.
by the deputy commissioner, then the delay factor will not come in that way.
My lord,
You can't change the natural water course.
my lord, one more humble request.
No, there is a
My lord, we could have taken
lord,
immediate
One more
action
humble submission, my
if
lord.
he had come earlier on, my lord.
My lord, here in issue is that, my lord, according to section 28A, subsection 4, my lord, the deputy commissioner doesn't, the law doesn't confirm them to pass this order. Only to the extent of 1,000 value only he can do it, my lord. But here, violating the law, he has the threshold doesn't comes under
which section?
section 28A of the land grant rules, my lord.
Rule.
Yes. My lord, page number 16, my lord, last paragraph.
The assail in this AWSIL, in this public interest litigation, is the decision of the deputy commissioner whereby path of the land of the canal originally at measuring path of the land canal is changed by the order of deputy commissioner at the instance of one private person. Respond, no. He joined them, you joined him here.
My lord? The order, my lord,
That Rupal Patel or Rupen Patel
not
is
made a party.
not made a party.
My lord, I'm not asking any prayer against the builder, my lord. My prayer is, my lord, whether the deputy commissioner can pass this order as per the law, my lord.
That's important.
My lord, there are two issues I reported, my lord. One,
Canal path of is B Kharaba land in survey number 77, 78A, 79B, 79A, 81A, 82, and 84 of the Kumbena Agrahara, HARA village. in survey number 85 and 86 of the Bellathur village, Bidarahalli, Hobli, Bangalore East. It is the case of the petitioner that the decision to change the course of the canal is not only amounts to tinkering with the public resource property, but the decision also stands illegal in light of section 28 capital A of the Karnataka Land Revenue Act
Karnataka Land Grant.
and grant rules.
Karnataka land and rule, ma'am.
Like,
My lord, I have mentioned page number 16, ma'am.
with permits. This 28A will not. Will say only.
My lord, 28 subsection 4, my lord. 28 subsection 4, my lord, it says the deputy commissioner shall on receipt of such application make such inquiry as he thinks fit, and if satisfied that the applicant is eligible under this rule for the grant of land in exchange for the land relinquished, determine the market value of the land to be relinquished and also of the land to be
Not
granted.
refer in the order, you argue it. Notice returnable on 21st April.
This is number 11,
Complaint.
Mr. Chandra Tariga K.
Correspond number 2.
Pardon.
But Lordship has already heard the matter. But with respect to construction of Malad, I have already filed Malad the affidavit before this court. Senior counsel Rajesh Mali has argued. Malad, I filed the affidavit. It is.
Respondent number 2 shall construct the building on the premises concerned in accordance with law only after obtaining the necessary permissions and sanctions from the first respondent. If the already constructed portion of the building violates the sanction plan or the building bylaws, the same shall be removed or demolished by the second respondent. The writ petition is disposed of accordingly.
One submission. But yesterday itself, Malad, we have given a sought for permission. Malad, let there a direction to the Malad, the authority, if Malad, my application has to be considered, Malad, for granting of the license.
For granting.
Malad, yesterday itself, I have filed in the online, Malad.
Good, fair enough.
Please, please.
This is number 12, Naya Tara BG.
Is that so motu matter?
Let's, on the last occasion, this honorable court had directed us to file an affidavit, Millets, laying down the time requirement for placing the guidelines on record.
Said that guidelines are being framed.
Please, Millets. I have placed the affidavit on record. I have 5 minutes.
Don't think, Lord,
You have filed the affidavit.
It's not there. Millets.
When you filed? Once.
Millets, I filed it on 17 March.
It is there.
17th March.
The last is of
15th March. 17th March.
17. Other
You postpone it.
Please.
My lord,
My lord, if I may make a submission, my lord. My lord, similarly, last time had passed necessary orders if we could file synopsis or comparison chart. My lord, if I may place on record, my lord, the comparison chart which we have drafted on behalf of respondent number 3.
Just give it to me just now. Give it to me just now.
I thought at page number 2, document number 1, part A, my lord. Just highlighted, my lord, the key points by Calcutta High Court, the Law Commission report, and the report submitted by the learned amicus. Similarly, part B will reflect with respect to Mumbai High Court, Law Commission, and the Calcutta High Court. And my lord, we've just come up, we have requested with respect to parenting rules. That has been provided, my lord, with sample schedule and document number 2 and 3, my lord.
Lot of work is done by you.
My lord,
Lot
we
of
as
research.
the NGO, my lord, because we are fighting for this, my lord. Some form of custody guidelines be established.
But the High Court, Bombay or Calcutta or whatever, then Law Commission report and the suggestions by amicus.
Amicus, my lord.
So which is the best that you have not studied?
My lord, all the key points are already there, my lord. It is just put it down on paper, my lord, and get it enforced, my lord. All the key points are there, my lord.
I think, my lord, the central government is saying they need 6 months to even start the process because they say still consultation has to be done. I think some, my lord, guidelines will have to possibly come from this court insofar as.
Wait for the guideline. When you are going
It'll
to.
take at least 6 months.
Taking
I don't know.
6 months' time.
6
If-
months.
It won't.
My lords, may I please read the relevant portion of the affidavit?
Read it. Please read it.
The answering respondent further submits that it has initiated a process of consultation with the relevant stakeholders and has held preliminary consultations with various stakeholders such as all states, UTs, Ministry of Home Affairs, Ministry of Social Justice and Empowerment, Ministry of Labor and Employment, Ministry of Health and Family Welfare, Ministry of Law and Justice for inputs and relevant case laws, Central Option Resources Authority, Department of School Education and Literacy, National Commission for Women, National Legal Services Authority, State Commissions for Protection of Child Rights. Further, National Institute of Public Cooperation and Child Development and National Institute of Mental Health and Neurosciences also have been requested to prepare model draft guidelines while determining issues of child custody and submit to the ministry. However, further consultations are required given the complexity and sensitivity of the issues involved. It is further humbly submitted that as the subject matter of framing of guidelines involves expertise and consultations from many stakeholders across ministries, departments, states, UTs, legal experts, child psychologists, social workers, families affected by child custody cases, etc., including the Ministry of Law and Justice being the nodal ministry for guardianship and custody laws in India. A committee also needs to be constituted for framing of appropriate guidelines while determining issues of child custody. Therefore, it is respectfully submitted that at least a minimum timeline of 6 months is solicited from the Honorable Court in this matter.
It's a minimum time period, not a max. It's a minimum time period of 6 months, which means it may not, in my humble submission, will not happen for the next 2 years. Till then, not anyway, this is not in any way.
Let we have the benefit of their guidelines.
But it may not come in 6 months also.
Well, we will impress upon
They need a minimum time period of 6 months. And because they're still saying the process is going to start. See this.
Several judgments.
Minimum what is added by you or by?
This is a policy making. It will require some time.
No, my lord, I'm saying now many high courts have adopted some of these as guidance for, my lord, the courts here. something that your lordships can also direct until they form the guidelines.
See, it can't be done overnight.
No, not overnight. I'm not saying over. I'm not at all saying. I'm not even suggesting that they should be directed. Your lordships not ultimately initiated the suo motu proceeding in order to examine as to what should be done, especially in case of parental alienation of children. And that not is not going to stop. It is going to be there every day.
You invited the suggestions from the general public and the different parties.
No.
No, not from the general public, my lords, but by, with various organizations that
From different stakeholding parts.
stakeholders
They've
and
asked not
organize-
various
but
departments of the government to
record-
give their suggestions.
Of the
I'm
record, I
not saying
have
it's
been-
bad, Lord. It's a good thing that they're doing it. But until that is done, Lord, I think your lordships can consider laying down some guidelines as an intermediate step to do everything else. Because Lord, various other high courts like Bombay, Calcutta, Gujarat, I'm not Gujarat, Chandigarh, Delhi, have all adopted certain principles which have been my lord, accepted and more or less accurate right now. Ultimately, once if they come out with guidelines, that will override everything else.
Both of you spell out the common.
Yes, I can do that. I'll give it to your lordship, not in a form of a table of what can be done.
Common suggestions or guidelines.
Yes.
Which forms part of the rules of the different high courts and the law commission.
Yes.
In addition to what you further suggest, could be referred to them for
Yes.
incorporation.
That also can be done.
Proposed in the proposed guideline.
There is also something that we can do, my lord. Independent of all this, I can also give it to them.
That's right.
And but till then, your lordships may consider this, my lord, because similar orders have been passed by other high courts, where one of the NGOs has come out, my lord, with a complete comprehensive guideline as to how to proceed with it. High Court of Bombay and Calcutta have adopted that and said that is something which can be adopted until not they come out with the guidelines. And that deals also with the requirement of child psychologists, especially in cases where there's parental alienation towards a non-custodial parent.
You just come out with the guidelines in your own way.
Please.
You're given the comparative chart or table, but you give the guide.
Not in my report, not I've come out with those, with a full guideline as to how it can be proceeded with. In my report, I've put it down, Lord. So if your lordships can examine that.
Micah's report also is quite comprehensive with
Very
respect to the guidelines.
It's there, whatever is required is there, but how it has to be adapted, not is.
I have not seen with that details. We'll see and then.
Yes.
Plus
Wait.
I got a date maybe.
22nd of 23rd of June.
Wait.
Or after one, after.
May have it, Lord, and at least some guidelines, maybe it'll.
23rd of April.
23rd.
Sir, my pleading point, sir, to comply with your order last time, I submitted my pleading points. And I stand for children, the victims. And they are trapped in these man-made laws. So how to protect these children is the issue. So I have submitted 35 points. Because this is child custody issue, is a word customary law.
I've not got a copy of this.
You copy
So
to.
you are part of the
No, sir,
judiciary.
madam, you have to give me a copy. Give me a copy of it.
Sure. So, it is the customary world law. After divorce, it is compulsory by force. They have to go to the family court so that the custody of the children is decided. And then any remedy or anything to talk about the customary world law is the anti-world law activity. So no remedy can be implemented for the children. So the children will continue to suffer. Now, this is the customary world law, 38B, and 34A says only the member state nation can go to the court. So this is the dead law. Member state will never go to the court because they have signed the agreement with the United Nations Charter that they will comply with the ICJ law. So any remedy, the government will suppress it. They will not allow to implement it. And the medical education issue is the proof of 24 years.
So while adjourning the present proceedings to 23rd of April for further consideration, since, what's your good name?
Dr. Kamla Nag.
Dr. Kamla
Nag.
Nag,
Who
NHS.
appears for in person, is permitted to put forward her suggestions to the learned amicus curiae who appears in the matter, as well as to learned advocate Miss so and so, for which NGO?
For respondent number 3.
For respondent 3, that's NGO. to be considered in its proper perspective, in order that in course of the hearing of the public interest petition, suggestions of learned party in person are considered, and at the same time, the valuable time of the court is served. Great.
Great.
Yeah.
You can allow some and do it.
This is number 13. Sohani Yola.
Appear for the petitioner.
Right.
Yes, we have sought for a few directions by this honorable court regarding implementation of the Emblems and Names Act 1950.
Lord, that's covered by the Madras High Court judgment, my lord. I have given it, my lord, in the last. Forward, please, my lord. Only to pursue, my lord, but of course, it is the state who has to implement it, my lord. Certain directions by the learned single judge of the Madras High Court, my lord. Sir. Sir. Sorry, last time he did not. Madras. Madras. It is not. Where is it? Ah, yes. High Court of Madras, yes. Let's over. Para 65. So this is regarding some number plate, my lord, misuse of number plate, my lord. Number plates for the vehicles. And having emblems on the number plates, my lord. So same direction will apply to, please, same directions will. Please, my lord, please, my lord.
Para 29, I have included few, your lordship. I have sought from this honorable court few directions. Your lordship may kindly consider that.
Para
And there was
29.
this article about Orissa High Court, a similar PIL was filed. I would just like your lordships to go through yesterday's newspaper. I've just marked the 11th.
Yesterday it was there.
Yeah, on a similar lines.
Correct.
PIL was filed.
It is notices issued.
Yes, your lordship. Notice has been issued to the
Yes, I
central government.
read it, yes. So we'll dispose it of.
Yes, your lordship.
Where is your paragraph 929?
29,
Where is
para 29. Few points to be considered by this honorable court I have mentioned. And at para D, I have mentioned to issue direction to the state and central government. The fine amount is very less, your lordship. It's just 500 under the Act, 1950 Act. So that has to be increased to 5,000 is what I have sought for.
I think the state has increased. It is increased, state has increased. It is for the state. So resolved for all. Please, madam. Respect of the fine, my lord, it is for the state, my lord. In
My lord,
respect of
we
the
have no objection to the writ petition being allowed. You want to implement the act.
Yes, Your Worship.
Right.
Till number 14. Turn. Given Neeral.
Before petition. All of this is regarding the my lord, the government orders authorizing the my lord, the work board to my lord, register the my lord, the marriages. Those my lord, government orders are under challenge before my lord in the state PIL.
This government order dated 3/8/2009.
Yes, my lord. Yes.
Where is that?
3/8/2009.
Where is that?
My lord, that is the previous,
That is not on record.
yes. That's not, my lord, that is my lord, succeeded by the above my lord at annexure A.
Correct, but where is that original order?
And annexure B.
That is also seen, but
My lord, that is order number is a football lord. That's the same order, 3/8/2009. Your lordship is
Same order.
referring to.
Okay. All right. It is there. You are.
Lordship, read that third condition. Type copy at my lord in page 53.
Original Nikah now.
My lord, after careful examination of the matter, the government is pleased to authorize the Karnataka State Board of Works and District Work Advisory Committees to issue marriage certificates to the Muslim applicants after fulfilling the following conditions. My lord, neither under the Waqf Act or under any provisions of the law, my lord, such a government order could be, my lord, the source of the government order is, my lord, is a question. The objection reasons of the Waqf Act is, my lord, entirely different and distinct. And my lord, the marriage under the, my lord, the Muslim law is being a contract between two individuals.
But what is your prayer? Let us see the
Yes,
some defect in your prayer.
Yes. Two prayers have been sought.
Same order. No? Third party.
Same, my lord, same.
No, three. Are you not supposed to challenge that 3/8/2009 order also?
Your lordships.
You are supposed to incorporate in your prayer.
Yes.
The challenge to this 3/8/2009.
2009 order also. I have to.
Do
That's, I
it.
noticed it.
Do it.
Please, I'll amend the writ petition. I'll amend the writ petition.
Otherwise, the prayer is little bit incomplete.
It's a transfer.
There is, because there is some nexus between the two orders.
Please, that is.
And logically, they have to be connected.
That is, my
So-
lord, it continuation of the, my lord, the previous.
Still,
seriatim, seriatim.
some,
Yes,
so when shall we keep?
make
22nd
one-
of April?
please.
Make one request, Maharaj. Now I'm appearing for an impleading applicant. Well, largely, my lords, I am sailing with the petitioner, but my lords, there is some apprehension that there are some averments made regarding the role of qazis in this entire marriage process. Now, my lords, our apprehension is that this, in fact, this honorable court has already passed certain orders regarding the role of qazis. The Qazis Act has been repealed. Now, this should not be used as a sort of
That
backdoor
repeal-
entry for them to come back.
That
So-
repealment has led to issuance of
Correct,
this.
Maharaj, correct.
Yes,
Now there are
It's a
some
motivated.
there are some averments now in the petition, very worryingly, which says that there is, in fact, qazis need not be government appointed. They need not be recognized by the government. So in the guise of any order passed by this honorable court, this should not be a backdoor entry to overcome that. So only to that extent, Maharaj, I filed an impleading application. If I could just file those documents and record ones, I'll be in a position to assist this honorable court. I have no.
We grant this implement application.
Yes,
Where is that
If it is sailing with me, my lord, if he says that he is sailing with me, lord, I cannot have any objection.
IA, one of 20.
Obviously.
Partly he
He didn't
says,
say
you are
that.
not
No,
sure.
no, you are for whom?
But I appear for the Waqf board. Lordship in the earlier motion bench order has said, of course, I am only a beneficiary. I don't have, the government has to support and the government is quiet. I thought maybe I'll just lend a shoulder to them by stating, my lord, that the source of power, just if a lordship would permit me, not these.
You are
stamps
lending your support to whom?
to the government. Because I am the authority that they have appointed, they should have filed a, not, the stamps, not this 1976 Marriage Registration Act is an act which requires every marriage to be registered. Now, under that, the government has got powers to appoint registrars. It does not say who are these registrars. So there can be registrars of stamps also. There can be a registrar anywhere else also. Now, by an executive order for this community, because there is no enactment, if I may just say so, there is no enactment under which a sub-registrar can register this marriage. And it was always being registered by the Qazi and certificate were being issued by the Qazis. Now, after the abolition of the Qazis Act, they were still continuing to do, which created a lot of havoc in the sense, your lordship would also aware, with no disrespect to anyone, there can be multiple marriages also. And now this became an issue at the passports office, at the visa giving office. So they wanted some government authority who knows that these are the mosques that are there in the state. These are the qazis or persons who are eligible or competent to perform. Looking at those things, the government thought that the board would be the best person because it has an information about all these things. Now on to the source of power, my lords. An executive order can always be defended under Article 162. If the power to delegate is there. Under 76 Act, Section 4 empowers the state government to appoint a person as a registrar. Now they have appointed board as one. Maybe they could have done it in an amendment way.
So according to you, they are the registrars.
Yeah, registrars.
Indirectly appointed.
Indirectly, like registrars only, and they can appoint as many registrars are possible.
We'll hear the.
Well, that is not the statement of the state government. That's coming from Waqf board. State should say that these orders are issued under the Section 4 of the 76 Act. But that is not the case of the government.
You file your reply.
Filed my objections also. And my lord, let us assume for a moment that it is to be Stamp and Registration Authority. Under the Stamp Act also, their scope of power is not to register a marriage.
Right.
So here it is for convenience of people. Your lordships have stayed the order. My lord, it is causing a lot of inconvenience.
We'll hear in the.
I'm just only at this much,
Yes.
not anything saying.
We'll consider. We'll not leave the matter. We'll.
Yes, my lord, even my lord.
We'll hear the matter
Yes,
on
yes.
after you
Yes.
amend your.
Yes, my lord, Qazis Act, which is the reference is made, even the Qazis Act, which was there in force, my lord, did not empower the Qazis to register the marriage.
We are on.
They are not authorized to register the marriage even under the Qazis Act.
So all of you explain to us the history and then
Please,
Yes.
subsequent development.
Well, could I be permitted to file my affidavit then, Maharaj?
Today you are granted, your implement is granted, you file affidavit.
We'll file.
My lord, I pray for some time, my lord, to file my statement. I pray for some time.
You're 22nd of February.
Obliged.
Obliged.
Hopefully, my lord, on that day, my lord, will conclude it, my lord. I'll amend it.
Obliged.
Seal number 15, Mr. Samir Sharma.
Hearing for the petitioner, the matter pertaining to experts under the Indian Evidence Act, the Bharatiya Sakshi Adhiniyam.
Yes.
Please,
That
Milord.
is also
Milord.
important.
Please, my lord. In this case, my lord, I've just received it, my lord. Today I've received it, my lord. I'll file during the course of the day, my lord. I've received the instructions today, my lord. I'll serve my friend a soft copy of this, my lord. Today morning I've received.
Let us see that section. Something was noticed after you argued the matter by me.
Please.
Which section? 79A
79 capital A of the Information Technology Act
and 64, 63.
and section 64 of the Bharatiya Sakshi Adhiniyam.
Yes, live.
Section 79 capital A, your lordship finds at page number 169 of my petition.
Page number 45.
Page number 169.
45. Sector.
The Bharati. Actually petition nage hakidini.
Please.
Yes, you are making a panel of experts or you're affiliating more institutions. What is the thing that you are coming up with?
My lord, the act says, my lord, that if your lordship may kindly see, my lord, 30. It can be given to any of the government agencies, either central government or the state government.
Correct.
Please.
See, no one is finding fault with the provision of the act. That is
Please.
not a challenge over
Please,
here.
please, my lord.
See, you have to issue necessary notification nominating those persons. Now, given the number of cases in the state,
Please, my lord.
but you have made only one institute in whole of Karnataka.
That's true, my lord.
That is not sufficient. It's
That's true, my
grossly
lord.
insufficient.
That's true, my lord. Under section 77, it is the only one expert here, my lord. That is true, my lord. It's no dispute about it, my lord. The only one thing, my lord, for the time being, my lord, what I request my learned friend and also the court, my lord, is this, my lord. This BSA, my lord, is administered and enforced by the Ministry of Home Affairs. However, my lord, here it's only the Ministry of.
It's already your central government.
Please, my lord. Therefore, my lord, as of now, my lord, if your lordship may kindly see, as of now, I have got the information and the from the Ministry of Electronic and Information. Therefore, my lord, I'll have to get from them also, because the reason is this, my lord. How many of them are they going to?
See, you should come up with the mechanism.
I'll come up, my lord. Today I've received it, my lord. I've received today, my lord. I'll place it on record. I'll place it on record.
It's very important. It affects everybody in this
Please,
court
my lord,
hall.
I do understand, my lord. Section 79A says, my lord, it is only for the purpose of that section, my lord. That is the interpretation my learned friend is saying, my lord. I'll place it on record, my lord. I'll place everything on record.
In fact, if I may only say,
Section 63 will interact with 79A in what way?
Section 63, if your lordship were to kindly see, it is at page 65 of my petition. 63 interacts with section 79 capital A of the Information Technology Act through section 39 of the BSA, which your lordship finds at page number 59 of my petition.
39.
Page number 59. Page number 59, section 39. Page number 59, lordship for to kindly see subsection 2. When in a proceeding, the
Now,
court,
these experts under section 39 are different from experts under section 79.
in fact, if your lordship for to kindly see, on below the subsection 2, the explanation says, for the purposes of this subsection, an examiner of electronic evidence shall be an expert. Now, this examiner of electronic evidence is situated in,
Expert in 79, under 79A.
please,
Experts contemplated under section 79A
please, 79A,
may form part of the experts contemplated in 39.
yes.
Still, they are different.
In fact, if your lordship were to kindly see, the word, in fact, if your lordship were to kindly see, the term expert is mentioned only in a couple of places insofar as the BSA is concerned. In the Bharatiya Sakshi Adhiniyam, other than it being mentioned in section 63, reference is made to section 39 clause 2, which I read out. In section 39 clause 2 itself, if your lordship were to please see page 59, here it says, when in a proceeding, the court has to form an opinion on any matter relating to any information transmitted or stored in any computer resource or any other electronic or
So
digital.
your grievance is about inadequate numbers under section 79A.
Yes, because the appointment has to happen under section 79 capital A. The
No, it does not happen under 79. Right now, which is the agency treated as expert?
that your lordship finds at page number 250 of the petition.
Notification was shown last.
Please, that is page number 250, the State Forensic Science Laboratory, Madiwala. So that is at page 250. In fact, the union government was also impleaded as a party before the Honorable Madras High Court in the judgment which I produced before your lordship. There also, they have taken the same stand, saying that we will appoint experts.
Under 79A.
Under 79 capital A.
Lord, it 79A says, my lord, it is for that section under the, under that act, my lord, not under the 30, not under the BSA, my lord. Therefore, my lord, what my learned friend is saying, my lord, it is straight away covered by the Madras judgment, my lord. There's no dispute about it. However, my lord, I'll place it on record, my lord. Your lordship may have it, give me a shortest date, my lord.
If I may propose one thing before your lordships, the copy of the statement of objections I have not received. I will go through it. Whatever way I can assist your lordship, I will assist your lordships.
So once you complete your pleadings, etc., will
please, my lord.
Lordship may accommodate us by the shortest possible date. We will go through it quickly.
The issue is understood, but you have to explain it in a
79A
elaborate way.
Please.
79A of the IT Act is entirely different than section 35 of the BSA. I'll distinguish it, my lord.
And section 39.
39, I'm sorry, 39 of BSA. So therefore,
but the expert under 79A would be an expert under 39.
Please.
That's the only connection.
Please. So therefore, section 63, electronic evidence of the BSA, is connected to section 39 of the Information Technology Act through section 39. Is connected to section 79 capital A of the Information Technology Act through section 39 of the Bharatiya Sakshi Adhiniyam. So that is the bridge between these two reference points is what I would
the reason is this, my lord, 39 clause 2. There is a mention when in proceedings, the court has to form an opinion on any matter relating to any information transmitted or stored in any computer resource or other electronic digital form, the opinion of examiner of electronic evidence referred to in 79A of the IT Act. Therefore, my lord.
So there may be cases under section 39.
Yes.
Relating to the soliciting the opinion experts, which may be referable to the area where the electronic expert functions.
Please. So if I were to put it across
only
like
one of the area or category.
Please. If I may just put it across this way.
79A is bound to be you. Where are you?
If I may put it across this way, if I were to lead evidence, electronic evidence before a court of law, and once the matter is set down for the stage of evidence, now to show the probative value of that piece of evidence, I will have to necessarily bring this expert as contemplated in 39 clause 2 and he will have to come before the court and depose. So therefore, I understand at the time of filing of a suit, for example, I may need not produce this certificate. But at the time of adducing evidence or marking exhibits, I might have to bring this particular expert and then make him depose before the honorable court. So therefore, the expert
Number of experts to be appointed under 79A will benefit the operation of 39 also.
Please.
Because section
So it is all
39
the more
subclass 2.
It makes all the more necessary to increase the appointees.
Please.
Number of.
In fact,
Is the direction, my lord, by the Honorable Madras High Court.
in fact, if it is not as if
Or as a matter of suggestion,
Please,
see, just like how doctor evidence is recorded in MVC matters and criminal matters.
Please.
Here also you can prescribe a person having such and such a qualification can be empaneled. Something like that. Rather than mentioning one government institution, which will hardly have around 5 to 10 persons.
In this case, they'll have to apply. They'll have to apply to the
You have to
central
make provision for
Lord, that is there, my lord. That is there, my lord. I'll place it on record. My
Right,
lord.
that
That
I've
is
already-
there, my lord. Whoever applies it, my lord, we are ready to give to them. That is what the counter also says, my lord. I'll place it on record, my lord. Any short date.
You come up with a holistic thing wherein an element of fee is also prescribed. Because they're not government servants. You see, you have government doctors coming in.
Please, my lord.
But whereas here, they will not necessarily.
Lord, the state has to do any agency of the state, my lord, or the central government. If they.
No, if you limit it to agency of the state or central government, you may not find sufficient number of persons.
The reason is that, my lord, an outsider giving an expert opinion.
Subject to cross-examination. See, subject to cross-examination. See, the point is, henceforth, you may have around, say, at least 10 to 15% of the trial court cases requiring this particular evidence. See, with the evolving technology, this becomes very crucial. And there will be a boom with regard to it. And if you don't appoint experts whose evidence can be accepted in court of law, then in that event, the cases will not get resolved. They get just stuck over there. Now itself, whatever is referred to Madiwala Forensic Laboratory, it takes ages for it to come back. See, you don't get it back immediately because of lack of manpower. That has been the experience, right?
That's true, my lord. That's true, my lord. I understand.
A simple handwriting
Expert.
Expert that is referred to this particular laboratory does not come back so easily. They'll have to dwell on ballistic. So many things are there. So you need to have a realistic
Lord,
aspect.
if your lordship directs
And
this,
that
my
the
lord,
government should trust its citizens, sir. You need to understand, it can't have an attitude of thinking citizens are thieves or
no, it's not
something
that.
like that. It has to trust its citizens and make laws.
The reason is this, my lord.
We believe in Hobbesian, we do not believe in Hobbesian philosophy, but Lockean philosophy here.
In fact, if I may only assist your lordship, the extant procedure through which these experts are appointed, that I've already produced before your lordship at page 252 of the petition. There is a scheme for notifying examiners of electronic evidence wherein it says it is only central or state agencies who have to apply. There is an application formula. Then there must be a process. After a multiple stage review, a particular entity is designated. Now that your lordship finds at page 252. For complete transparency, I have produced before your lordship. So I think that is what my learned senior was adverting to when he stated that there is a particular mechanism which is already present to appoint them. That your lordship finds at page 252. Lordship comes to page 254 of the petition.
We'll hear on it.
I'm grateful.
When shall we?
Lord, any short date, my lord, because I have received it today, my lord, I'll file it in a day or two, my lord.
21st April.
Please, my lord.
Green bench matters, paper 16, Sharish Bandari.
Great.
Notice is issued here. Notice is issued. Press matter. Will issue, you appear. Will issue notice. Notice returnable on 28th of April.
20. Wait, my lordship.
So, number 17, Mr. Abhijit, yes.
For the petitioner, my lords.
Yes.
This is a writ of certiorari wherein I'm challenging Annexure A, the impugned endorsement which was issued by respondent number 6, the Deputy Conservator of Forest, wherein he has refused to grant NOC in my favor, stating
Within-
that my area.
It is within 10 kilometers of the Kali protected area.
Yes. Now, the fact to be considered is that there is already a gadget notification issued in the year 2016, that is Annexure D, which says that 7 kilometer is the eco-sensitive zone of KTR. It is then followed by Annexure E, my lords.
Annexure E.
Annexure E, page number 56, wherein another fresh proposal has been made, wherein the area earlier prescribed as 7 kilometers, they are intending to reduce it to 4 kilometers, 4 to 4.5 kilometers. Page number 57, second para. Shri C. Jairam informed the state government has reduced the ESZ area from 1,201.94 square kilometers to meters to 312.52 square kilometers due to public demand. And the cabinet subcommittee state government meeting held on 10 to 17. No eco-sensitive zone is proposed on the western side due to interstate boundaries with Goa. And on the northern side, also no eco-sensitive zone is proposed as it is borders Bhimgad Wildlife Sanctuary. The extent of ESZ zone varies between 0 to 4.5 kilometers.
But this is in process at the best.
It is still pending.
So-
Now, the fact to be considered is that.
So on the basis of pending matter, we can't grant.
No,
relief.
but then the 2023 Godavarman judgment, it clearly says that a minimum of 1 kilometer ESZ is to be observed in respect of all protected areas. And this will not apply if there is a draft notification or a final notification which has been issued. Now, the concept which is followed by the respondent is that it is within 10 kilometers. But then in Goa Foundation case, it is very clear that there is no order.
Let us see Goa Foundation.
Page annexure.
It's produced.
Yes, it is produced, sir. Annexure F.
Page, paragraph.
Page number 109.
What you are saying is not probable. Anyway, show us.
Page number 109, sir. Here it is clearly stated that in the result, we declare that point 4 by order dated 4/12/2006 in writ petition number 460 of 2004, Goa Foundation versus Union of India. This court has not prohibited mining activities within 10 kilometers.
Where you are reading page?
Page number 109, 71 para, clause 4.
Yes. By order dated 4/12.
Yes. Here it clearly says that this court has not prohibited mining activities within 10 kilometer distance from the boundaries of national park or wildlife sanctuaries. Thereafter, there is another order which is at annexure G, page number 117. This is the order dated 12/11/2018 passed by the Supreme Court, wherein a list of 21 national park has been given. And in respect of this, 10 kilometers is to be observed as ESZ. Reason being, there is no proposal been received in respect of all of these 21 national parks. Whereas in respect of the KTR, a proposal is already been issued, sir. Therefore, in this case, in this order, that is annexure G, the Supreme Court in page number 119 has clearly stated, para number 21. Para number 21. under the circumstances, we direct that an area of 10 kilometers around these 21 national park and wildlife sanctuaries be declared as eco-sensitive zone by MOEF. The declaration be made by the MOEF at earliest. Now, since there is no order prohibiting mining within 10 kilometers, the default concept of 10 kilometers cannot be adopted. And even this honorable court has stated that this default concept of 10 kilometers is a non-existing concept. That is in Annexure H, my lord. Wherein a similar kind of endorsement was quashed.
What do you say?
My lord, it's coming up for the first time. I'll take notice, my lord.
Notice written ever on 29th of April. Learn
Apply.
it. Additional government advocates with the Nilofer Akbar accept notice. The rest of the on behalf of the state, rest of the respondents will be served. Yes.
The Writ appeal matters,
My
number
lord,
18.
my lords, a date may be given, ma'am.
Already given.
Seal number 18, Mr. Rajat HV.
Seal number 18. Matter where, my lord, in 2011, I've been granted 3 acres of lease land by the government. And that lease was subsisting. And in the meantime, a rival claimant arose in 2018. Yes.
With number. Ah, there.
18. But survey number 57 was government land of 76 acres. The government granted me 3 acres on leasehold for 30 years. That is an undisputed position, blood. In the meantime, this was in 2011. In the meantime, in 2018, one rival grantee raised a question that the land was granted to her. This came up before the assistant commissioner, white page 82. Assistant commissioner said, go back to the Tahsildar, let the Tahsildar verify the records. This was in 2019-20. Tahsildar verified the records and said initiate 136(2) proceedings because as per the calibration, the entire land is granted. And my 3 acres 36 is shown. This will not kindly see page 117, the Tahsildar's order. The English portion is at page 120. This is the Tahsildar's office of Tahsildar's order. 11, 12, 20.
Page?
Page 120, annexure N.
120.
120. Now, in this, the Tahsildar, kindly see 123. There is a table here. In this table, I am at serial number 11. Chimney Hills Education Institute, 3 acres, 20 guntas. The Tahsildar calibrates the entire lands granted and says 76 acres are granted. That table, your lordships has that table at 123. Yes, blood. I'm at serial number 11, Chimney Hills. Tahsildar says entire 76 acres is granted. This person who is claiming 2 acres 20, we don't know where this person is situated. Kindly see the note below. But as above, it is known that already 76 acres 3 guntas is transferred. And since the area shown by the applicant has been measured and reported by the land surveyor, it is not clearly stated in the sketch in which area 2 acre 20 falls out of the above sanctioned area. And markers of the sanctioned area as proposed in the proceedings of the Honorable District Collector are not shown. This is what is said regarding the land grant of Rehmat Unisa.
What is the total extent of the survey number?
76 acres, 3 guntas, total extent. So therefore, the entire survey number had been saturated with allotments. So question arose as to where this 2 acres was there. They referred it under 136(3) to the Deputy Commissioner. In the meantime, Deputy Commissioner, while passing an order, in the meantime, there was a development. Kindly see page number 221. 221. It appears that this same person, Rehmat Unisa, who is claiming this 2 acres, 20 guntas of land, she had come before the authorities in the year 2005-06. 224 is the English copy.
Here, my lord, this same issue was taken up by the revenue authorities in the year 2005-6 regarding the genuineness of grant of this Rematunisa. At page 227, shall I read, my lord? In the bottom portion, it will check the documents in the file of the special Tahsildar proceedings. Shall I read from there? 227, 2 paras from the bottom.
Who is this?
This is the earlier proceedings of the same Rematunisa before the revenue authorities, the assistant commissioner
Pyarajan
and Rematunisa.
who are they?
They are the respondent, Lord. Respondent in this matter. Now, Lord, in 2005-6 itself, it was decided that these grants were bogus grants. It said, as per check the documents in the file of the special Tahsildar proceedings of the office, RRT, order passed as follows. As per copies of grant certificate on file, it is found that in survey number 57, an acre of 3 acres of land to K. Parajan and 3 acres to Rematunus has been issued, and Tahsildar M. Nagendra who signed the grant certificate, but at that time, M.S. Nagendra was working as Tahsildar. It appears a detailed report has been submitted regarding the land by the Tahsildar and Assistant Commissioner. According to the above Tahsildar report and records, the property in question, there is a doubt about the plaintiffs being officially surveyors. Since this court does not have authority to verify the authenticity of the documents in regard, I have come to the opinion the proposal submitted under section 136 of the Land Revenue Act to verify the authenticity of the documents in evidence. Appeal filed the appellant against the order of the Tahsildar dated so-and-so regarding so-and-so is found. Is the document submitted by appellant is found to be a fake document, to be superficial. I've ordered the appellant case to be dismissed, and by sending a copy of this order to the collector, I've requested to conduct inquiry under section 136(3). The formula way back in 2005-6 itself, this Unisa's case was dismissed, holding that they were fraudulent documents. She comes back, resurfaces in 2020 by a fresh case without disclosing the earlier case, and moves before the assistant commissioner. Assistant commissioner sends it back to the Tahsildar. Tahsildar again says, start a 136 proceedings without knowing that earlier it was already decided. Now the special DC passes an order, annexure A to the writ petition, page 56. Without considering any of these documents, he upholds her grant as genuine, the Tahsildar, and without being aware that it was referred to the deputy commissioner to assess that the documents are fake. Kindly see, page 59. Heard the arguments and perused the material and documents available and record and report submitted by the Tahsildar. The last 2 paras from page 59. Contention of the respondent is that the original respondent has been granted with land in question as per grant certificate dated 11/179. Tahsildar, along with this report dated 6/121, submitted the copy of the OM dated 10/12/78, issued by the divisional commissioner OM, and 10/12/79 issued by the deputy commissioner. Letter of the deputy commissioner so-and-so, and the sketch prepared. The above documents clearly substantiate the genuineness of the grant of land in question in favor of the respondent, Rematunisa. Under the circumstances, I am of the view the respondents herein are entitled to transfer of revenue entry in respect to the above land. Since I proceed to following the order. Following order, the grant in favor of the original respondent, Rematunisa, in respect to the land bearing so-and-so, situated at Chikbadamara so-and-so, is a genuine one, and respondents being legal heirs are entitled to. Court did not go into that 2005. The special deputy commissioner, Millard, was kept totally unaware of the 2005-6 order of the assistant commissioner saying this was a bogus grant and it was not a genuine grant.
The 2005-6 order at page 224 in respect of same land.
It is the same land. Same land, same survey number.
Same survey number.
Yes, that your lordships will get it at page
57.
Yes, page 220.
It is 57. Same.
Yes. It is the same land. 220. 222. It starts at 221. English copy is at 224. It says survey number 57, extent of 6 acres, because there were 2 grantees, Parajan and Rematunisa. Now, Lord, in the wake of this situation,
yes,
Lord, the fact is this, Lord, this order, which is at page 224, they only doubt saying that the records are not checked. Records are not checked. This is what it reads, Lord. As per the copies of the grant certificate.
But today, there is no challenge to 224 order.
No, there is no challenge by them only. By them, there is no challenge. And they are the ones who have suffered that order.
Even if you have some argument with regard to the veracity or otherwise or anything about this 224 order,
Yes,
in RN number 241, it is not under challenge.
but that is only, it's not in a challenge. That is in reference to 6 acres of land situated therein.
Or learned senior advocate, Mr. Vivek Reddy for the appellant. Learned additional government, Mr. Parish for this one state and its authorities, and learned advocate Mr. So-and-so for the private respondents upon service of the copy of the appeal in advance. Full stop. While confirming, the learned single judge has dismissed the petition of the appellant petitioner and has in turn confirmed order dated 27/3/23 passed by respondent number 1. Number 1, is it correct?
Respond number. Yes, my lord.
Number 1.
No, respond number 4, my lord, special DC. Respond
No,
number.
number 4.
Sorry.
Therefore, number 4, the special deputy commissioner. By this very that order.
That order annexure.
Page 56.
Hey, annexure A.
Annex A,
Page 56. Page 56.
By the said order. Passed under section 136 into 3 of the Karnataka Land Revenue Act 1964. Comma. It is declared that the grant in favor of the original respondent, as the respondent herein, Srimati Rahmatullah Nisa, in respect of land survey number 57 at measuring 3 acres at Chikka Navara village, Yeshwantapura Hubli, Bengaluru North, is treated as genuine. And it is further held that the legal heirs thereof, legal heirs of the said Rahmatul Nisa are entitled to transfer of revenue entry in their favor. Full stop. It is the authority has directed for mutation of the name of the respondents. Full stop. It was pointed out from the record by learned senior advocate for the respondent that as back as in the year 2005-2006, in respect of very survey number for proceedings of revenue appeal number 241 of 2005-2006, at the instance of the respondents herein, Srimati Rahmatullah Nisa and one Sri K. Parajan had taken place, in which a finding was recorded that the documents submitted by the appellants in the said proceedings, that's the respondents herein, in relation to, in support of the claim in respect of the land in question were fake, and the case of the appellant was dismissed by the appellate authority, thereby refusing to accept the validity of grant certificate.
Yes.
Full stop. There is no dispute. It could not be disputed that the said finding and the said order continues to operate from having not been challenged by any of the respondents. Full stop. In the circumstances, a strong prima facie case is made out. Appeal is admitted. Impugned judgment and order of learned single judge is hereby stayed.
Please, oblige.
If the mutation has taken place, the competent authority shall make endorsement. Mutation has taken place.
Yes, my lord, it has taken.
It was stated that the mutation pursuant to the directions of the authority and as per the impugned order passed, direction of the special deputy commissioner has already been effected.
Status quo.
Full stop.
Status
It is already effected. Effected, sure.
quo. It is affected, sir. It is affected, my lord.
In that regard, therefore, it is directed that there shall be an endorsement below the mutation entry that it will remain subject to outcome of the writ of
Please.
present writ.
Please. Oblige. In the IA, what have we sought to stay?
Stay of impugned order, stay of the order, there shall be stay of the order passed by special deputy.
Special DC, please. Oblige.
Seal number 19, T. Prakash.
That I represent the. I challenge the order of the learned single judge, my lord. That respondent number 6 here in my lord. He has encroached the public road and he has put up the construction, my lord. And we have filed a complaint to the BBMP. Since the BBMP did not take any action, we have filed the writ petition, my lord. In the meanwhile, my lord, the respondent number 6 files a civil case. And there he gives an undertaking that in case if the public authorities pass any order to the effect that he has encroached the land, he will demolish it. On the basis of the said undertaking, my lord, the trial court grants an interim order of injunction. Subsequently, my lord, the BBMP authorities hold a survey inspection along with the survey authorities, and they found that there is an encroachment. And they have also drawn the sketch showing that there is a clear encroachment on the road and he has put up the construction. Even after all this, my lord, BBMP is not taking any action in the matter. Therefore, we have filed the writ petition. The learned single judge says, my lord, since matter is pending in the civil court, let that civil court take a decision. My submission to lordship is, my lord, he himself has given an undertaking to the civil court, stating that if the public authorities hold that he has encroached land, he will demolish it. On the basis of it, my lord, the BBMP should have, since they have already held an inspection, they have drawn the sketch, they have submitted the report also, they should have taken the action. Therefore, my lord, learned single judge has committed an error in dismissing my writ petition. That order I have challenged it, my lord. May I request your lordship to kindly have a look at the sketch, my lord, for a while. 248, my lord. 248. Page number 248, my lord. The last document, my lord, 248, my lord. Page number 248.
There are cross suits filed.
Yes, my lord.
Cross suits filed.
Yes, my lord. Suits are filed, my lord.
4572.
Yes, my lord. But there is an undertaking by the very.
Regarding permanent injunction.
Yes, my lord.
To the very subject matter.
Yes, my lord.
So it
But
can't be dealt with in the writ petition now.
but there is a memo of undertaking given by him itself, my lord. That could be seen at,
Dismissed.
that could be seen, my lord.
Nothing doing. There is no merit. Suit, you fight out in the suit. You can't invoke the jurisdiction under 226 simultaneously
Not by
when you are
virtue-
fighting the suit.
By virtue of the undertaking given by him, my lord, the BBMP should have.
That
taken
also you work out there only civil court. Yes. Next.
Seal number
Yes, next.
20, K. Krishna.
So notice returnable on 17th June.
Lord, I am permitted to serve the counsel who is appearing in the
In
connected
addition
matter.
to the normal mode of service, learned advocate for the appellant is permitted to serve the learned advocate for respondent who appeared in the before the learned single.
Match up.
Seal number 21, K. Shahbaz Hussain.
21.
21.
Appearing for the MESCOM, my lords. It's against an interim order which we have filed an appeal, my lords.
By Mr. Dhyan Chinnappa, can it kindly be passed over?
But then there is a delay.
Please let them.
You are the only respondent appeal.
Yes, my lord.
I'll only respond. There's a delay. I'll file a reply, my lord. Kindly keep it on Friday. I'll file a reply to the condemnation application.
I don't think, let him file, if he has objection to the main 51 days delay, I don't think he should have.
I'll file a reply to the mail.
So delay is condoned.
No, I'll file a reply to the mail.
Or learned advocate General Mr. Srivaran Shetty for the applicant appellant and learned advocate Mrs. Vansu for the respondent. It is to condone the delay of 51 days that the present application is filed. The accompanying affidavit explains the passage of time full stop, the applicant is electric supply company, comma, an impersonate body, therefore decision-making process as the administrative stages to pass through. In that view, it could be said that there is no element of negligence or indolence on part of the applicant. Full stop, the sufficient is made out to condone the delay to the extent of 51 days. Period of delay is condoned, application is allowed. Appeal to be listed. Appeal to be listed some other day,
Please immediate committee.
whenever you want.
Any days, 2 weeks maybe.
4th of April. Appeal to be listed shall be listed on 4th of April.
Please. Great.
This is number 22, state appeal.
My lord, the delay, my lord, is state appeal, my lord. There's delay of about 39 days, my lord. Take out notice.
Notice written on 16th of June.
This is number 23, Mr. Hanumant Reddy G. Number 23.
To appear for the National Highway Authority. Lord, the National Highway Authority is the appellate. Lord, the appeal arises from the order passed by the Learned Single Judge. Lord, setting aside the acquisition proceedings, who are the petitioners in the writ petition. Lord, the entire acquisition, my lord, has a checkered history. Lord, the contention, my lord, was of one, the contention.
You notice.
Yes, my lord.
Notice returnable on
Your lordship,
29th
give a
April.
shorter date, my lord, so that.
29th April.
Yes, my lord, can we serve it on the lawyer who had appeared in the?
In addition to normal mode of service, learned advocate for the appellant is permitted to serve copy of the appeal to learned advocate who appeared for the original petitioner before learned a single judge.
I'm obliged. my lord.
Status quo shall be maintained in respect of the subject land by both
Yes,
sides.
this all, my lord, because it's.
By both the sides.
Yes, yes.
By both the sides. Therefore,
So 24 is adjourned. Still number 25. With Ramesh.
Appearing for the appellant.
195 delays. Delay.
We were in the RP, my lords. RP was filed against the order of writ petition.
Then notice will have to go. Notice
Notice have to-
returnable on 17th June.
My lords, I'll serve it on the
You can
a
serve
party
in
appearing in the
every
writ petition, my
matter. We
lords.
need not pass that on. You can serve the council. You're at liberty to pass.
Still number 26. Mr. Sanjay Krishna.
Look, there are two connected matters. Writ appeal number 223 and 225. There's an order of
20.
status quo that is the order to be listed on the 25th.
25th. 25th. 25th. File in the register. File in the register. So connected is 200 and
223 bar 2025 and 225 bar 2020.
two appeals.
Two appeals. Common order.
This shall be listed with cognate appeals number 223 and 225 of 2025 on 25th of
That is it.
this month.
This month.
March.
Party in person of the C certificate.
223 is the main on which the impugned order is. So with that, if the other two can be flubbed.
That is what we did done, right?
It is against common order.
It's a common order. I'm not sure what.
That is what it is done. If you don't understand what can be done, yes.
Number 27. Mr. Shetty Vignesh.
Yes.
Lord, I'm included by the order passed by my lord learned single judge, my lord page number 28. The my lord appellant is a nationalist bank. My lord, I initiated action under my lord Surface Act pursuant to my lord account become NPA. I issued a 13.2 and 13.4. And my lord, I also issued my lord sale notice. The sale notice, my lord, SLP for the my lord honorable single judge at my lord page number 30, the writ petition. The prayers, my lord, sought at my lord page number 38. Issue, my lord, the writ of certiorari and cautioning the notice dated 23/1/2025 under section 13(4) of Surface Act. Issue the respondent bank by fixing a e-auction mortgage property on 25/2/2025. Lord, I'll just draw my lord's attention to my lord the sale notice which I published at my lord on 25/1.
While being aware that the order not to be challenged is an interim order passed by a single judge, it could be immediately noticed that the order has a clear trapping of finality. In view that learned single judge has directed the respondent, that's the appellant hearing, that's the bank to re-deliver the possession to the petitioners upon payment of 10% amount to be deposited. In that view, notice returnable on 28th of April. There shall be stay of the impugned order till the next date.
This is number 28. Mr. Padmanabh Ola.
157 days notice.
Please, Milo, I beg to appear for the appellate notice.
Do it.
The
Notice
delay in the-
returnable on 17th June.
Number 29. Mr. Nayak NR.
Appellant.
I appear for the respondent number 1.
I am not mortgaging my lot before bank authorities.
Pardon?
My property is not mortgaged, my lord.
No.
I am a stranger to the bank, my lord. Then I have filed writ petition before this honorable court because partition was took place in the year 2000. We are having separate possession. And later, we have made application before the DRT, go before the civil court. Civil court we have filed. Interim order was granted. Later, the application has been filed under Order 7, Rule 11. It was rejected. The matter appealed before this honorable court in RFA, my lordship. Subsequently, my lordship, when the interim order was granted, stating that 10 crores rupees they are liable to pay. This property was mortgaged by our father, my lord, after 10 years without our knowledge. We are not party to the mortgage deed, my lords. Now restricted by learned single judge stating that we should not file any application before this honorable court or any court. That is the order has been passed. Plus imposing 1 lakh rupees, my lordship, what we have suppressed, my lordship. When the property is not mortgaged by us, because we have brought as a legal representative of our father. Father died, therefore we have brought legal representative. But partition deed is suppressed by the bank authorities, provided the loan in favor of the partnership firm, which is headed by my father. He is a sleeping partner, and his property ought to have to be mortgaged. But the entire property has been mortgaged for 8 crore 50 lakh rupees, my lords, without our knowledge. And we are continuously before the court, my lords, if one or the other reason. They want to take section 14, advantage of section 14. They want to take possession of our properties. Therefore, I am before this honorable. I have not suppressed anything. But 10 crore rupees I have undertaken before this honorable court in RFA, but I could not able to get. Therefore, my father property, let them take. And auction sale, my lordship, which is allotted in favor of my father. And whatever proceeds available, my lordship, it can be sold out my father's property and take them. We have no objection, my lords. Because our properties are separate, my father's properties are separate. At the time of granting loan, this aspect is not brought by my father. About partition took place about 10 years ago. And it is appeared in EC, my lordship, how they can grant without our presence. Nobody is purchaser coming before because it is mortgaged to the bank, and whatever property available to our father, my want to sell. Now, public auction notice has been issued on 8th April, my lordship. They want to sell the property, entire property. And my contention is not at all taken. 1 lakh rupees cost has been imposed and directed us not to file any application, any case before any court.
This is section 14 order. Even sorry. Dismissed. There is nothing, absolutely nothing.
My humble request, my lord, cost kindly may be waived.
This is
Because
not
it
a-
is not possible to pay us, my lordship, because kindly maybe look into your lordship.
You
We are
go on-
not,
You go on suppressing the earlier litigation, earlier suit.
15 years.
15 years.
no.
And go on filing the petition.
it-
That to the order, kindly listen, order under section 14 is
Your
challenged.
lordship,
In 226,
Yes, Lord.
you have to go to the tribunal. From no standpoint, it is.
my
against-
last line kindly, I am not permitted to file any writ petition or any case.
More you
No.
argue, we are inclined to increase. the
Now
cost.
cases are pending, my lordship. I should go before the court.
This is what.
Yes,
Cost
my
is-
lordship. That is the last line, my lordship.
Cost is 1 lakh. We can say 1,25,000. Cost.
But one submission.
Allah, that order kindly may be, my humble request, my lordship, that order kindly may be recalled because this order restricted us. I can't go before the court, my lordship. Evidence I should lead because suits are pending.
You tell us candidly, you filed the appeal for deletion of cost.
Absolutely.
But kindly maybe look into my lordship. This is the order.
Cost is reduced to 25.
It is made clear that petitioners.
I don't think welfare fund, Lord. We'll let
Right.
Hmm.
it be.
Allah, it is made clear that petitioner shall not file any other writ petition before court where
That we are-
measures taken by the
We are not-
respondent.
That can be examined in approved proceedings.
Then therefore,
Right to litigate
therefore,
is-
my lordship, because
We know
this,
that your right to litigate cannot be closed, but cost, we are not interfering anything in this appeal, but except reducing the cost to 25,000.
please.
Next. We'll pass the order.
Serial number 30,
Kindly may I have it, my lordship, 25,000 total out of 1 lakh.
Less. It is
Because
less.
it is not possible for them. Because several litigations are lost, they have. So therefore, I am coming before this honor.
Next.
Please.
December 30,
Lords, in
More
this, we
time?
have filed a compliance affidavit on the last date by
Appears
giving the
for the-
schedule.
Elections.
Yes, we have given the
Appears
date,
for
my
the
lords, by
complainant.
15/6 will complete the election. The election process is already begun. 15/6, my lords, we have given the
They-
date of.
They have directly disobeyed the earlier undertaking that they will complete the election by March.
Some other. 671 square.
They have got two orders made, changing the composition of the board of DCC Bank. Therefore, they did not conduct it before 19th March. Now they file an affidavit saying by June we will complete it.
Process has begun, my lords. Therefore, the election
Program is
authority,
issued.
please,
Program is issued.
please, that we have placed it on record, man. Placed it on record.
Page number 7, man.
Kindly see the earlier order.
Last date of hearing, my lords, was pleased to dispose.
So you are not touching the writ appeal.
Yes.
Because the order is.
Now the schedule is.
Author of the order is.
Order is, my lord.
If you are insisting on writ appeal, it has to go before different bench. That's the reason. It's my order, writ appeal, writ petition.
I understand, my lord. Particularly with regard to contempt, your lordship may kindly peruse the earlier order. They had undertaken to complete it by 19th March.
No, no, no. If you are insisting on writ appeal, if you are insisting on writ appeal, this has to go before a different bench. If you are not insisting on writ appeal can be dismissed. You are withdrawing the writ appeal and only contempt is being heard. Then probably we can hear this.
Lords, the writ appeal was already disposed of. We had filed an application for
Writ appeal
extension
is
of
not a
time.
pending matter, my lord.
Extension of
Writ
time
appeal
to
is
conduct
disposed of,
elections.
an application
And now
for
the schedule is
extension.
issued. Now that the schedule is issued, my lords may
Not
kindly
scheduled, my lord.
permit us to,
Only contempt is survived.
only contempt,
And
may
your
be
lordship may-
permitted us
your
to go
lordship
on
may
with the schedule.
kindly grant me a week's time. They have definitely manipulated to circumvent the earlier order where your lordship showed indulgence and granted them 3 months' time to conduct the election. That time they utilized it for changing the composition of the board, and now they have notified the election. Kindly grant me a week or 2, my lord. I will bring that to the notice of the
They
court.
may have to challenge the bylaw, my lords. That is a separate cause of
To
action.
you if time is granted. When the program is issued.
My lords, we issued it on 15/2/25, my lords,
220.
and the election to be held by 15/6.
It is after, beyond 3 months, after 3 months.
Please.
Yes, my lord.
We'll see.
We have complied with
Not
the act.
statutory period, my lord. This is a direct manipulation. I will point out that.
Point of that. When shall we keep?
No, my lord, not after the election. Kindly grant me 2 weeks' time. By the first week of,
Petition before the other single.
16th April.
please.
Great.
So commercial appeal, number 31.
For the appellants in this matter, my lord, this is a appeal under section 37 of the Arbitration Act.
We'll hear it. This press.
Yes, Lord, the lower court records may have to be summoned, my lords, because our case is not that there has been a wrong appreciation of evidence, my lords, because that is not beyond the scope of, that is beyond the scope of review under section 37. We are saying there's non-appreciation.
So lesser and less.
Lessee, my lords, lessee's appeal. 25-year lease, my lords, that's been terminated.
So premature termination of lease.
Premature termination.
Non-payment of rents for over 2 years, my lords.
For, my lords, we paid rents. They didn't provide any maintenance services. And we wrote a number of letters asking them to, my lords, undertake at least essential maintenance. That was not done. We wrote a number of letters over many months. And my lords, this was really the last straw when we said that we have no option but to, we didn't say we will not pay you rent. We are saying we are withholding payment of rent until you undertake the maintenance of the building, my lords, because it's a
All of
safety
this has
issue.
been considered in detail, my lords, and
We will show, my lords, what has been considered.
Honorable
and what has
Tribunal
not
has
been
construed the
considered.
contract and said that under the contract, we had the right to terminate.
Notice returnable. When? After?
Any date, my lords. I'll
After
file
vacation.
objections.
Very.
18th of June, before the next date, the registry shall see that the record reaches this court from the office of arbitrator.
Well, it's from the lower court, my
From
lords,
the, sorry,
commercial
from the court concerned.
But in the meanwhile, my lords, could I request for stay of the.
Lords, I am opposing the stay.
Once the record comes, it is.
Very well.
Nobody will proceed without record.
Very well.
There's an amount of 15 crores outstanding as of today.
We've already deposited, my lords.
They've deposited 30 lakhs. There have been directions to deposit which they're in
That's-
violation of today, and an amount of 15 crores is outstanding.
We'll file the calculations, my lords. In accordance with the orders of the commercial court, we actually deposited what was directed by the commercial court.
You are in possession.
Yes, my lords.
They have given us possession in October, my lords.
We have not
In
given
fact,
any.
I have produced all of those records in the trial court. They gave us possession, then they tried to claw it back after I've been in possession for the last 2 years.
Anyway, Manoj, we'll produce all those records.
The parties shall maintain status quo.
Manoj, I have already leased out the premises after may I file that, Manoj, so that there is no confusion about status quo as on this date.
Of, the
Give me that number.
property in question. So as not to precipitate the.
As may I file this memo, there are registered lease deeds already that other parties are in possession. This has.
Could not have been done.
They have
my
not
lords.
been in possession
It
for
could
the
not
last
have
2
been done.
years.
Let me explain why. If my learned friend
May I just
produces new
enter this so
material,
that
let me
as of
explain why
today,
that could
at
not
least
have been
it's on
done.
record.
Whatever it,
Please, Manoj.
then you are tendering after we grant the.
Afterward.
Because I had kept it ready. The lease has happened immediately after I have taken possession of 22nd October. I have filed all of those papers in the section 34 and in the execution proceedings. They have not been in possession. It has been a vacant premises that I have been in control of. In fact, we had come in writ petition in which the Honorable Writ Court has also held that I am in possession. There is some dispute as to whether it was given to me by their security guard or their lessee security guard, but the fact is I am in possession. And I have already executed and registered lease deeds in relation to the property.
Learned advocate with tenders, what you are tendering?
The lease deeds, Manoj. 2 lease deeds
Then document
of
is
14th
But the
February and
status
8th
quo-
February.
Status quo order will continue, whatever it means.
Please, Manoj.
Status quo as on date, as on today.
As on today, Manoj.
Deeply obliged. And any transactions, Manoj, will of course be subject to the outcome of the appeal. Deeply obliged.
Deeply obliged.
Seal number 32.
Lordship,
Rohan.
the appellant.
Itigidi.
Your Lordship, I appear for the appellant. Service on all respondents is complete. There is an IA filed seeking condemnation of delay of 8 days. So,
8 days.
yes, my lord.
IA number.
1 of 24, my lord.
1 of 24. Heard learned with respective parties. Delay which has taken place in preparing the appeal is of 8 days. Full stop. Paragraph from the accompanying affidavit. Sufficient cause is made out to condone the delay of 8 days. Full stop. Application is, delay is condoned, application is out. Appeal may be listed some other day.
Very well, my lord.
It requires little longer hearing.
May I request for a date if your Lordship pleases?
Whatever date you choose.
Any date convenient to your Lordship.
29th July or April.
Very well, my lord.
My senior, your Lordship, MC Ravi Kumar, has suffered from an attack. He has come home from the ICU. I would request at least 6 weeks time.
Little longer or late. We
Very
will
well.
know. And it will go to 23rd of June.
Very well, my lord. I'm grateful.
Days. 22 noise.
But 33 is urgent. Seal number 34, Mr. H.V. Devraj.
Who appears for anybody appears, delay of 97. First time it is coming.
No, the notice has been served.
Notice is served.
Sir.
It is. Or learned advocate, Mr. So for the applicant. Full stop. None appears. Respondent, though served with the notice of this application, paragraph is filed, seeking to condone the delay of 97 days. The occurrence of delay. Is explained in the accompanying affidavit. Submit that after the judgment and order passed by learned single judge. The applicant had intention to prefer the appeal. certified copy was available on 1/4/24, whereafter advocate was instructed to prepare the appeal. It was stated that learned advocate wanted certain information and documents. It was stated that time was consumed in obtaining certified copies since some other person intervened, which resulted into passage of time leading to delay. It was submitted that the delay has occurred beyond the reasons, that reason for the reasons beyond control of the applicant. From the facts stated above, it could not be we would not say that any negligence is attributable to the applicant. So time appears to have been consumed in undertaking the process of instructing the advocate and preparing the appeal papers. In overall view, sufficient force could be said to be made out. Delay deserves to be calmed down. There is a delay of 97 days in application. What about the appeal?
That appeal, that land single judge, confirming the order of the land district judge, where this is pertaining to the that high tension line drawing compensation paid. That the diminution value has been paid. That land say that district judge ought to have been looking to that compensation paid is a lower side. It has been determined in double compensation. That what that we have paid without considering the note of that as well. May kindly look into the land the district judge order, wherein that starts page.
Or like notice returnable.
The notice has been served.
No, appeal money.
Appeal. May be posted along with connected appeal that 1/2/15 of 2024.
Written on 17th June. To be listed, the present appeal shall be listed with connected appeal number
1/2/15/2024.
1/2/15/2020 on the same day.
December 35. Avi, sit Rath party in person.
Your Lordship, the condonation was delay. The condonation delay was condoned, and in this appeal, Your Lordship, my name was appearing on 31/7/2019 for the confirmation, and the bank failed to state what happened in 2 days, and I was issued a termination on 2/8/2019. And second ground, Your Lordship, is I was not given any adverse performance. Any adverse performance was ever communicated to me,
So your services are terminated
Your Lordship.
on the ground that you are not suitable during probation.
Yes, my lord.
Your Lordship.
There was termination also, there was also one charge sheet also against the probationer, and he was imposed with the punishment of
Then
stoppage of one increment earlier.
After punishment determined.
No, earlier to this termination, then when they, earlier that because of his writing so many letters to the.
Foundation is penal.
Just
He
What
challenged both
distinction
these.
between foundation and motive? Foundation is disciplinary action.
Disciplinary action is earlier for writing letters and all.
You dropped it and you terminated, you said that not suitable.
No, my lord, that is depending upon that, rather single judge has clarified everything on the basis of the appraisal. Because that there is a system, my lord, every month the branch manager where he is working has.
You are saying
appraisal.
there was a departmental action. There is a departmental action against you.
departmental action was there.
We'll consider.
Your Lordship.
Admitted. Or done, learned part in person. What can be done? You are is out of service. Or learned part in person. Petitioner part in, appellant part in person. By him. The motive and foundation aspect is not. Actually, Even learned single judge has not done.
And there was a review was also dismissed, my lord.
Counsel, if it is discharge simpliciter, he cannot question it.
Yes, my lord, that's.
But if there is what you told, that allegation is there, he can very well question it. That requires that warrants and inquiry to be conducted.
And your lordship, the charge said the punishment is based on it's on the basis of a preliminary inquiry, your lordship. A regular inquiry is to be also be conducted as per Article 311 of 2.
Foundation of your order of discharge was misconduct, allegation of misconduct, isn't it?
My lord, even if for the sake of argument, they are saying that my performance is not.
So termination during probation, it becomes punitive because it
My
was the
lord.
background of the allegation.
My lord, in this regard, what happened, my lord? That he used to send a threatening letter to the manager stating that you should not give this.
Sir, whatever it is,
There was a
I
disciplinary
think-
action and minor penalty was imposed.
We'll hear it
we'll
finally.
hear it. That's it.
You need to improve your pleadings
Your lordship.
to be listed on 18th of June for finally.
Oblige, your lordship.
Improve upon your pleadings. Pleadings are not sufficient.
Your lordship.
So we are not in advisory jurisdiction, we're telling you.
Oblige, your lordship.
36 is urgent. Seal number 37.
Here for appellant, my lord.
37.
We have challenged the Annexure E, my lords. Annexure E is an endorsement issued by the KSRTC saying that adoption son is not eligible for appointment on compassionate ground, my lords.
Previous order. While selling the impugned order of learned single judge, the appellant party in person, that's the original petitioner submitted. That though the order is of discharge simpliciter on the ground during the probation period, it preceded by the allegations of misconduct and the preliminary inquiry conducted in that regard, full stop. This aspect could not be refuted at this stage by learned advocate for the respondent. Full stop. The petition, the appeal deserves to be examined finally, to be listed on which date? No, to be listed on
18.
which?
18 June.
18 June. This much we'll add it, we have added. This observation we have added, yes, which is
Seal number 37.
I appear for appellant, my lords. Annexure E is an endorsement issued by the authority, my lords, saying that, my lords, as per the policy, my lords, adopted son is not eligible for appointment. We relied on the order of this honorable court, my lords, where the corporation has given, my lords, eligibility insofar as adopted son. Considering that, my lords, he is as good as a natural son, my lords. The honorable learned single judge has rejected on the ground that, my lords, the decision of reliance sought against the KPTCL, not insofar as a KSRTC. This is for insofar as KSRTC is concerned, it is not last page, ink page number 17, my lords, of order of learned single
so
judge.
if the scheme does not provide for giving compulsory appointment to adopted
Yes,
son or
my lords.
daughter, you
As per-
can't get it.
Yes, as per the, my lords, amended rule, my lords, adopted son is also equivalent, my lords, as good as natural son, my lords.
So
My
the-
lords, I have
Did-
relied
when
on
did
the
the-
decision
when
of the,
when did the death of the employee occur?
my lords, employee, my lords, adopted in the year 2003 itself, my lords. Death of the deceased is, my lords, 2014. And the order, the communication sent from the officers, my lords, with regard to.
Rules were amended in which year?
2021, insofar as state is concerned, my lords. Under Article 12, my lords, the KPTCL, KSRTC also, my lords, it is one of the wing of the state government, my lords. In view of that, my lords, this adopted son also eligible for this, my lords. Even there is a decree of declaration is that with regard to.
All right, notice. Prima facie, we are not with you. Notice returnable on 12th of June. Somebody appeal? So somebody is appealing?
Renuka.
So notice was issued earlier. But then wait. Then wait, somebody is appealing.
Renuka is a panel advocate.
So wait.
Yes.
Number 38. Mr. Narayan.
APF for the appellant, my lord, in this batch of appeals, my lord, in 2 appeals, my lord, 2 appellants have died. I'll bring the LS on record, my lord. I'll ask him next week, my lord.
Next week, 7th of.
Please, my lord.
Oh.
Please.
April.
My lord, instead of 7th, my lord, may seek 8th or 9th, my lord.
9th.
9th, I have some inconvenience. 7th would be all right, my lord.
I'll send the
Then-
9th.
17th.
After 10th, my lord.
17th. After
10th.
after vacation.
No, after 10th,
After 10th.
After 10th. 17th of April
please, my lord.
or
A little earlier also is all right.
15th April.
Except 15th, my lord.
Then 16th April.
Please. My lord.
Only in one case, my lord, ex parte interim order was granted. In that case, my lord, in the first case, ex parte interim order was granted. Your lordships wanted to hear all these cases.
But any
They are all identical cases.
I have preferred appeals, my lord. They are pending before the appellate authority. By virtue of this appeal, my lord, he did not go in appeal before the.
No, I will.
But this
Only in one case interim order was, last time also, my lord. Your lordship has extended interim order only in the first case.
petitions were filed against the order of controlling authority
Controlling authority.
without going to appellate authority.
Yes, my lord.
Why?
I have preferred appeal, my lord. They have bypassed that and they have.
May I make submission, my lord? My lord, this is not with regard to gratuity. My lord, gratuity amount paid is in order. The tax deducted, I have been directed to refund the tax deducted TDS. It has already been remitted to the tax department, income tax department. They have not, form 16 was also given. I don't know whether they have claimed refund or not.
You are for employer.
Yes, TDS, whether the authority has got power to direct me to refund the tax which has already been remitted to the income tax department. And I have not deducted any tax from the total eligibility of the amount under Payment of Gratuity Act. Under private scheme, they are entitled for 30 days for every completed year of service. Whereas under Payment of Gratuity Act, only 15 days. I did not deduct any income tax which is under Payment of Gratuity Act. This is over and above the amount paid under Payment of Gratuity Act. Therefore, tax has already been remitted. Under controlling authority has already held that the amount of gratuity what has been paid is in order. But I have been directed to refund the TDS. TDS, how can we refund?
My lord, he could not have deducted tax at all.
No, I will convince. Therefore, my lord.
When it is argued, my lord, on 16th,
And
I submit.
I said, here, order of learned single judge is not an executable order. It is not an executable order. Whereas order of the controlling authority is an executable order. If without hearing on merits, if interim order is granted, it is as good as rejecting, allowing the writ appeal without hearing me.
That's all.
Yes.
Yes, ma'am.
Interim order may kindly be continued,
Oh, my
wherever it is.
Only, my lord, this is TDS, my lord, TDS.
My lord, my appeal before the
TDS,
appellate
no,
court.
no, TDS, this is TDS. It is not with regard to gratuity. TDS, my lord, if TDS is recovered in the interest payable on fixed deposit, if I am asked to refund TDS, which has already been remitted to income tax, whether deduction of income tax is proper or not, that is required to be examined. That is the order of the learned single judge.
Wherever it is there, it will be extended.
Macho, please. This is number 39. Mr. L.M. Chidanandaya.
150. 39, you are appearing?
Lordships, I request this honorable court to take writ petition 2023, your lordships.
Pardon?
WP 2023, I'm requested to take, your lordships.
203, yes, live 202.
File an application seeking consideration of my application for grant of quarry lease, your lordships. In respect of survey number 30 and 31 for an extent of 15 acres in respect of Tumkur district, your lordships, under Rule 8B of KMMC rules. My application was rejected, your lordships, but I filed revision petition also before the honorable court. I would request this honorable court to take annexure A1, page 32, the translated copy, your lordships. Annexure A1, translated copy. Page 32 is the translated copy. Which may permit to read para 2, your lordships. On verification of the document furnished by the competent authority, the applicant filed an application on 8/2/2011, seeking grant of the quarry lease for satite stone in survey number so-and-so to an extent of so-and-so at para 4 of the original file, that a portion of the applied area is overlaps to the applied recommended area as per 6 ml.
You got the remedy, madam.
Lordships?
Got the remedy under Rule 50.
Yes, your lordships. I had filed revision, your lordships.
You filed review.
I had filed revision. Revision has been rejected, your lordships. That's the order I've been reading at annexure A1, your lordships. Translated copy at page 32. I'm reading the order of the revisional authority. That's in challenge. Page 33 may be kindly looked into, your lordships.
Now, this revision is filed 4 years after the date of the order passed by the authority, my lord.
Lordships may kindly look into. The reason is why I'm reading is specifically at page 33, your lordships. My application itself is not rejected as per the records. When my application is filed, condonation of delay of 4 years will not at all arise as per the. In page 33, your lordships, the competent authority wrote a letter bearing so-and-so dated 23/5/2011 to head office requesting to furnish the information with regard to the area by applicant is open or not. So I skip, your lordships. They say there is an area, one AR Prasanna Kumar already filed an application. But as per the affidavit, he has withdrawn on 29/12/2012. The said application is withdrawn. The reason for rejection is my area overlaps. My area overlaps. The area applied by me is overlapped. The said application, which is in having conflict, your lordships, is already withdrawn as on 29/12/2012. May I request now, your lordships, to kindly see page 34, para 2, your lordships. On 18/9/2018, page 34, your lordships, called the applicant competent officer for hearing. The applicant was present for hearing. The competent officers were absent for hearing. At the time of hearing, applicant has filed a written statement stated that the applied area is an open area and Director of Mines and Geology, page 34, your lordships, page 34, para 2, your lordships, is an open area and Director of Mines and Geology, wide order dated 15/4/2013, directed the application of the petition to be kept pending. When my application is kept pending, your lordships, the question of the revisional authority and issue of endorsement at annexure A saying I filed revision belatedly and my application cannot be considered because of overlapping is not at all considered, your lordships. The total non-application of the mine by the joint director. My application is kept pending. And they say my application is rejected because of overlap.
What is it?
My lord, as I submitted to my lord, 4 years after the order is passed, my lord, the revision is filed. And in the revision petition,
Order of rejection
yes,
of renewal.
yes, not
Not
renewal,
Consideration.
consideration of the
Reconsider,
application,
reconsider.
yes. After 4 years, I can understand, my lord, if they had come immediately and said that this is an open area which is available. My lord, then we could have considered the application. My lord, now just parroting saying that for my personal reasons and health issues, without producing any documents,
And
that
you want
4
your,
years,
and you want your application to be saved under 8B.
yes.
Lordships, page 34, the Director of Mines and Geology has told my application is kept pending. That's what I'm reading, page 34, your Lordships. What I'm reading is, in the para 2, your Lordships, on 18/9/2018, call the applicant and competent officer, page 34, the translated copy of Annexure A1, where the revisional authority himself has heard the matter.
34.
Page 34, your Lordships, para 2, on 18/9, after the bullet points, 3 bullet points, your Lordships, on 18/9/2018, call the applicant, competent officer for hearing. Next line, your Lordships, at the time of hearing, para 2, your Lordships, of page 34. At the time of hearing, applicant has filed a written submission, a written statement and said that the applied area is open area. Director, Vide is letter dated 15/4/2013, directed to keep the application pending. My application is kept pending. It is not at all rejected by Director of Mines and Geology. The question of me going belatedly before the director of before the joint director hearing application overlapping is all secondary, your Lordships. The director himself has told my application is kept pending. When my application is pending, your Lordships, the question of rejection won't arise is my only consideration. And I'm very straightly saying that in 2018, the application is served to me. The copy is served. And no whisper about it by the joint director, whether they've not verified by the original records when the copy of the endorsement is issued to me. Now, as per the amendment KMM's rules, I'm seeking that my application is in existence. As per 11/3/2023 amendment, as per Rule 8B, my application should be considered. The rejection at my representation, which was given, is rejected at Annexure A, your Lordships. An endorsement is given. The same reason. First reason is overlapping. When there is no overlapping, the application is withdrawn. And next reason, my application is still pending and delay of filed before the joint director.
My lord, I'll clear that doubt, my lord. My lord, looking into the records, I'll clear the doubt.
Requires to be cleared because if the petition is kept pending, then 8B will.
Well, that's the reason why I made a submission to my lord that I will clear this doubt.
23rd April.
Obliged.
Much obliged.
That's one submission, my lords. Serial number 58, the contempt petition was disposed of. In this, my lords, they have mentioned in page 4 that subject to the result of the another say, SLP pending before the Supreme Court, which is nothing to do with me, my lords.
Which one?
What of state?
Which was the number?
Just a page number 58, my lords.
58 that contempt
Yes, contempt, my lords.
along with the other.
Yes, my lords.
4 and 5. So
My lords, they have mentioned, just I bought the 2 copies also, my lords, for ready reference. At page
58 may be segregated and posted on 25 up to the top. 2 are all right. 2 dispose
yes,
over.
yes, 2 dispose, my.
This will consider separate. 25.
56, my lord. We are permitted to withdraw to file the jurisdiction point of view.
Which one?
Serial number 66, my lord. Commercial appeal. Repeat, I have filed this before the show.
Company application.
Commercial appeal.
Commercial appeal number 152. Learned Venkat Ramanna MK seeks permission to withdraw.
And permit me to file the restitution before the court. And
Withdraw the appeal.
directly the registry to return my certified copy.
Placing on record the memo dated 19/3/25. Post of memo. It is following is stated in the said memo, then quote the memo. Post without expressing anything on the content of the. Without expressing any opinion on the content of the memo, the appeal is permitted to be withdrawn.
Registry may be directed to return the certified copy.
Also, the registry shall return the certified copy.
My lord, seal number 42.
Appellant, if the appellant so applies, while retaining the Xerox copy of the certified copy on the record of the appeal.
Lord, seal number 42, my lords. I appear for respondents. I seek a week's time to file response on behalf of High Court. My lord. Storage issue. My lord.
That High Court rules,
Please, my lords. I seek a week,
no replies filed,
a week's time, my lords. It's pending approval.
pending approval. 17th April.
Bless.
With your lordship's kind permission, my lord, serial number 87.
80 taken up, week up to next.
80.
80.
Why?
Some complaints is kept out. The state has to take some complaints, and one complaint has to be carried out by me.
So it is for non-compliance of office of this.
Yes, my lord.
So 3 weeks time is granted to comply with the office of business. With the contempt petition shall stand out of similar order in 79, but grant for, and similar order on in 81, 82. Pura sub 82, so many matters are there. 10 matters, 2 weeks. Automatically it is.
With your lordship's kind permission, my lord, serial number 87, my lords. It's an appeal under section 37 of the Arbitration Conciliation Act. My lords, the respondent has also filed an appeal. This is of the year 2022, which is being heard in Court Hall 2. On the last occasion, my lords, both the matters, serial number 87 and the other matter in Court Hall 2 were listed together. And it was listed today, but on account of the roster, it rises to the same award, same order under section 34.
87.
80 serial number 87.
For the respondent.
It was stated by learned advocate for the
Appellant.
appellant that
MFA number 7366 of 2022.
7366
of 2022, my lords. 7366, my lords.
7366 of 2022.
Yes, my lords.
22.
Yes.
22, which is a cross appeal arising out of same,
Not a cross appeal, my lords.
is a
Appeal.
connected appeal arising out of same judgment, an order of commercial court.
Not commercial court, my lords. It's a regular appeal. Section 37, my lords.
So how come this is commercial?
Not commercial.
How this has come here? Arbitration.
Arbitration.
Connected. Is connected to the present bill, which is listed before the different bench, full stop. It's connected, so maybe listed together.
In fact, that appeal is being heard.
The register is directed to seek appropriate orders on administrative side by placing both the appeals on administrative side. Yes.
Last week kindly, serial number 62, I press a week's time for rectification of the office objections raised, found in the verifying affidavit. 62, my lord.
So what do you want? Time?
I press a 1 week time for rectification of office objection.
22nd of April.
Much obliged.
Serial number 60, Your Honor. It takes 1 week time. Serial number 60.
16.
60.
60.
60.
Yes.
Place 1 week time, Your Honor.
23rd of April. Yes.
Serial number of 45.
45.
Yes, sir.
Hmm.
Sure. 1 week times. Praise for 1 week time, sir. 1 week time, praise.
No. PIL of
Tell that.
did before. Yes.
Passover matter, number 37.
Appeal for appellant, my lord, sir. May I request for
On behalf of respondent counsel, is
inconvenience, my lord, I have done next week.
Whenever you want,
We have for HR and
whenever you want,
next week. Next week, anything.
25th of April.
My lords, 27th.
Hmm.
May I request for 27th?
27th
Yes.
and 28th April.
230 matters, seal number 96,
28th April. April.
seal number 96. Lochana S. Babu.
Petitioner.
96.
Lord, I'm filing a memo with this pertains to, my lord, the filling up of vacancy in the Karnataka Administrative Tribunal.
Oh. We dispose it of if something is stated.
So your petitioner. Your petitioner.
The present public interest litigation petition relates to filling up of the vacant posts and to appoint members to the Karnataka State Administrative Tribunal. Full stop. While notice was issued, notice was issued.
Yes, my lord. 25th June 2024.
Upon issuance of notice, the court had annotated the entire order, 9/125. Today, when the petition comes up for further consideration, learned additional government advocates, Srimati Nilofer Akbar produces tenders memo dated 18/3/25, in which it is stated that in the process of recruitment to the post for my paper publication in the daily newspapers, namely the Times of India, in Bharat Rashtramat, and Vijayavani, which is a vernacular, of which the last two newspapers are vernacular, has been published on 9/2/24, inviting applications from the eligible candidates. And the last date was 9/3/24. It is further stated that 19 applications are received, which are forwarded to the Registrar General of the High Court of Gujarat. It was stated that a meeting of the search cum selection committee would be meeting to to further the process of appointment. It was further stated in the memo that in the meanwhile, one of the judicial members retired on 16/6/24, and to fill up the vacancy arising, applications are invited by advertisement dated 25/3/24, which is published in 3 newspapers, for which the last date is 8/8/24. Pursuant to, last date was 8/8/24. It is stated that pursuant to the same, 22 applications were received, and they are forwarded to the Registrar General High Court of Gujarat. It is further stated that since one more judicial member is to retire on 3/4/25, advertisement was published in 21/25 in 3 daily newspapers, and the last date for filing of the applications pursuant to the said advertisement is 7/4/24. Full stop. The memo, along with the memo, copies, along with the memo, notice dated 4/3/25, regarding convening of the meeting of the Selection Committee is produced. Also produced are the copies of the advertisement. Referred to above. Full stop. And you have the above details coming forth and placed on record. It is evident that the respondents are already active in undertaking the process for filling up the posts to the judicial member of administrative, judicial and administrative members in the vacant post in the Karnataka State Administrative Tribunal. Full stop. In light of this, the present petition is not required to be kept pending. It is disposed of with an observation that the respondent shall take the process to its legal end.
Seal number 97. SB Mukanappa.
You have not got the latest. Meeting is-
5-3 I got, my lord. 5-3.
Meeting is already held and everything is further.
My lord, that I couldn't because it was then. So I didn't want to make.
I appeal for the respondent number three, my lord.
Yes, the partly complied by the respondent number 4, result number 4. The arrears of the salary is not paid to. The last
It is for
occasion
2 weeks
also
adjournment, my
not
lordship.
for this court.
The advocate on record is not keeping well, my lord. Srinath,
Your senior.
yes.
And last occasions also is not.
But you take instruction from the respondent when they will pay the salary.
2 weeks time may be granted, my lordship. We'll comply within 2 weeks.
The only part to be complied with is the payment of arrears of salary.
Arrears of the salary.
Pursuant to
The
the
cost of
directions
25,000 rupees
brought
paid.
under the contempt jurisdiction. In this regard, learned advocate Miss so and so appears for the respondent. In this regard, learned advocate Miss so and so who appears for the respondent stated that since our senior advocate who is to conduct the matter is in indisposed health, time may be granted. Full stop. Time is granted up to 24th of April.
Much.
Obliged.
It is expected that the remainder part of the compliance shall be acted upon before the next date.
Yes,
And the
sir.
salary amount as may be due to the complainant shall be paid. For little more time. 28th of, but you pay in the mean,
Please, my lord.
28th July, or April.
Seal number 98. Okay, Maitreyi Krishna.
Appear for the complaint.
Here for the respondent, my lord. In the last occasion, this honorable court directed to pass the award afresh within 4 weeks. And accordingly, the office of the SLAO has passed a fresh award. I filed a memo only yesterday, my lord. I'll serve a copy on the other side.
I'll just have a look at what they have filed, my lord, or maybe given a week's time to make my submissions.
3rd April.
Please,
3rd April.
obliged.
Grateful.
Grateful.
It will not survive.
My lord, I'll just go through what they have filed. I'll make my submissions on 3rd of
occasion,
April.
The earlier award schedule 1 was not reflected, my lord. That here, the office of the SLAO has complied with. In the event they.
To be listed at 2/3.
Grateful.
Grateful.
Seal number 99. Anand Kumar C. Number 99.
Nobody is there. We'll go to 16th of June. Unpresent, stand out to 16th of June. Learned additional government advocate Shekhar. Raghavendra files compliance affidavit which is taken on record. Copy thereof may be sought to the petition.
Seal number 100, Mr. P. N.
Memo.
Mr. P. N. Harish.
You copy to the same order, same date.
Seal number 39. Seal number 40.
Matter. Let's, if your lordships could kindly take 20949, my lords.
My Lord, in this, the
petitioner
request
is
has
owner,
been
my lords, of-
considered. And, my Lord, I'm filing a memo along with the endorsement, my Lord.
Lords, there's no endorsement, my lords. Kindly your lordships may see, this is a matter where the petitioner, my lords, owns 38 guntas of agricultural land where there are little rocks and boulders, my lords. Department of Agriculture, my lords, was called upon, my lords, to give a report if removal of these rocks, my lords, would facilitate agriculture. A report was filed, my lords. Thereafter, the senior geologist, my lords, kindly see page 40, my lords, annexure F. He says, my lords, around 6393 square meters of rock should be removed, out of which 20% is ornamental stones, rest are waste rock. Based on this, my lords, this Honorable Court annexure K, my lords, page 50, had passed an order, my lords, directing them, kindly see, my lords, page 52 is the relevant portion. Admittedly, the land, your lordships got page 52, my lords, para 4. Admittedly, the land in question is petitioner's patta land and he desires to use it for agricultural purpose. The exact quantity of stones available and whether it comes under so and so is not placed before the court. In the circumstances, we direct respondent numbers 3 and 4 to consider such permits. They were not required to pass and give an endorsement, my lords. They were required to grant mineral dispatch permits. Your lordships may kindly see the photographs, my lords, at annexure B1, page 29. My lords, this is agricultural land. I'm removing those stones only for betterment of agriculture. Rule 3A provides for it. My lords, my lords, my request is from 2017, my lords. Annexure C is 2017. So this Honorable Court, my lords, in the year 2019, 4th April 2019, my lords, they directed, my lords. From 2019, they've not given us permits to remove it, my lords. They've been dodging, saying that is not there, this is not there. They keep dodging. Again, we came on the second round of litigation, my lords, again seeking the same prayer. They're not, my lords, they don't have to do anything. Kindly see Rule 3A, my lords, which provides for, kindly see Rule 3A, my lords.
What you are filing?
My Lord, I'm filing an endorsement to say that this is a government court land.
It's B Kharab land. I've produced the RTC, my lords. RTC at annexure A. Kindly see RTC, my lords, at annexure A.
My Lord, this is serial number 40.1. For 40.1.
Yes.
My Lord, I'm filing the endorsement.
Kindly see page 20, my lords, annexure A.
If it is B Kharab, it's government land.
It's kindly see, my lords, what to Vistirna, so and so. My lords, 1 acre, 4 guntas, my lords. It's not government land, my lords. It's my land. I have purchased this land.
See, if it is B Kharab, it's government land. If
No,
it is
the
A Kharab,
entire thing is not B Kharab. Kindly see their endorsement only, my lords. 0.
My Lord, let
My
this
lords,
endorsement
my
be
lords, the
challenged.
question
my
is
Lord.
just
I will,
this. The question is just this, my lords. I'm just removing for the purpose of betterment of agriculture. That's all, my lords. And this is provided by Rule 3A. Kindly see Rule 3A, my lords. Rule 3A, my lords. The following activities are exempted from obtaining, quarrying, lease or license. Your lordships are taking Rule 3A of Karnataka Minor Mineral Concession Rules, my lords.
You have to challenge this.
Yes, my lord, letter challenge, I'll meet it. My lord, then in the another writ
My lord,
petition, my
this
lord,
is
the
not
earlier
challenge.
one.
My lords, your lordships have already directed. The direction is still there, my lords. They cannot just go back. This order of this honorable court, my lords, was not challenged by them. Annexure K, page 50 was not challenged by them.
Factually speaking, now they might have realized that coming under government land.
Now let's see which I produced.
See,
Annexure,
RTC suggests
your lordships are
1.04 guntas. What is it?
yes, 1 gunte. 1 gunte. 0.01. It is 1 gunta.
1 guntas.
1 gunta. Then again, my lords, it's 1 gunta. In the other one, my lords, it is 12 guntas. I'm not asking on these lands. My lords, we just kindly see the photographs, my lords. We are just using it for agriculture. We are entitled to use it for agriculture. Kindly see their report, my lords. Annexure E, your lordships may kindly see, my lords. Annexure F, page 40, my lords, may kindly be seen. Their own senior geologist has given a report. Kindly see Annexure F, my lords, page 40. Even now, according to them, the endorsement says it is 5 guntas. My lords, we will not undertake in the government 5 guntas of land. But the remaining, kindly see, my lords, Annexure F, page 40. (39) is the report in Kannada. My lords, as per your lordships got page 40, my lords. As per directions of the senior geologist on so-and-so, so-and-so lands were inspected. During this period, the representative of the owner of the agricultural land was present, and he is informed about the intention to make it fit for agriculture. That's all land. During the inspection, it is found that 450 meters from so-and-so is, this is the location of the land. There being dolerite stones scattered at various places in the land, which are gray in color, there is no uniformity. The extent of this is about 0.2 acres. That is 2,131 square meters and 3 meters in depth. It is so-and-so, 6,393 square meters. In total, mineral about 20% is ornamental stones, waste rock. Hence, it is obtained that without causing damage to any public structure, permission can be granted under Rule 3AB of Karnataka Minor Mineral Concession Rules. This was considered, my lords. Not only this, your lordships may see Annexure D, my lords, the previous page, page 34. Your lordships gets page 34, my lords, which is English translation by the Assistant Director of Agriculture. Page 34, my lords. 33 is the Kannada version. With reference to the above subject, we had visited land in so-and-so, belonging to so-and-so. And when inspected, it was observed that agriculture activities is already conducted around this area in order to convert this land fit for agriculture. Since it is necessary to remove the stones and boulders from this area, it is obtained that permission can be granted within framework of Rule 3AB, Karnataka Minor Mineral Concession. My lords, considering these things, your lordships, my lords, at Annexure K, page 50, (52) is the portion, my lords, para 2, page 52, my lords. So-and-so, learned advocate for petitioner, submits that rocks and boulders are found in petitioner's patta land and he desires to use the land for agriculture purpose. She further submits that authorities are refusing to grant mineral dispatch permits and prays that respondents may be directed to issue mineral dispatch permits. So AGA was asked, my lords. Thereafter, para 4, my lords, was passed. Admittedly, the land in question is petitioner's patta land and he desires to use it for agricultural purpose. The exact quantity of stones available and whether it comes under so-and-so is not placed before the court. In the circumstances, we direct respondent number so-and-so to consider petitioner's request and grant a mineral dispatch permit to facilitate him to remove from the aforesaid survey numbers within so-and-so. After this, we've been giving them representations. They have not considered. That is why we are before this honorable court, my lords.
See, the entire thing so far has proceeded on the presumption
Yes, my lords.
that you own the property
We own the property.
on
There is no
which-
dispute.
on which the rocks are situated.
Yes, my lords.
And for agricultural use.
Yes, my lords.
So you want to make it fit for
Yes, please.
agriculture.
Yes, please. Yes,
Okay.
please. Yes, please.
Now, when your land is unfit for agricultural use,
Yes, my lord.
on that you don't pay taxes, number one.
Well, it's not the
And-
entire
and-
extent.
Not the entire extent.
Only
but
the-
where the rocks
Yes,
are
yes.
situated. And it get considered as a Karab land.
Yes, my lord.
Correct?
Yes, my lord.
But the RTCs produced by you
Yes, my lord.
do not show the existence of a Karab land anywhere
Yes, my lord.
in all the three RTCs.
All the three artists.
The three RTCs mentions
Be Karab.
existence of only B Karab land.
Yes, my lord.
So that means to say the rocks, unless the RTCs are held to be wrong, the rocks are situated on B Karab land, which is a government land, not your land.
My lords, kindly see the extent, my lords. It is 1 gunta, 2 guntas.
Whatever it is,
The remaining
the RTC,
Yes,
if you
my
look
lord.
at it,
Yes, my
there is no mention of A Karab at all.
we're not on A Karab, my lords. It is B Karab land.
No, there is no mention of A Karab at all in RTCs.
Yes, my lords. There is no mention of A Karab.
That means to say there is no waste area on your land.
My lords, maybe the RTC, my lords, we are not on A Karab or B Karab, my lords. We are on the only a short point whether those rocks could be
If
removed.
there is no disputed question of fact, we could have passed the orders.
No.
There is disputed question of fact according to them.
There is no dispute. Even, my lords, according to them, it is 5 guntas is disputed. Only 5 guntas, my lords. Let them find out, my lords. It's only 5 guntas my learned friend is disputing,
To
not beyond
verify
that.
and file objections, detailed objections. A
Let them
memo like
file
this may
detailed
not submit.
objections because last time,
To whom the land belongs to, what is the extent of land held by the petitioner, whether the rocks are situated on the land held by the petitioner or is it part of B Karab? File a detailed objections.
this was, my lords. We intend to improve the agriculture, my lords. That's all. We don't intend to make profit out of it. It is
My lord, in the first matter,
21039.
my lord,
Here
my
the
lord,
petitioner is owner
petitioner
of
had
2 acres, 17 guntas, my lords.
my lord, there is a letter written by the daughter of the petitioner.
My lords, I have already said, my lords, she has withdrawn that letter and have placed it before your lordships. That withdrawal letter I've already
I
served
don't
her.
have a copy, my lord.
I've already given her, my lords.
I don't have it.
That letter is
In this also, a similar endorsement has been passed.
let them file a detailed objection, my lords. Even in this, the same thing has happened, my lords. It is 2 acres, 17 guntas. My lords, the Department of Agriculture was called for, senior geologist was called for. Then, my lords, this honorable court in the year 2019, my lords, annexure J, page 42, passes an order. They pass an order, my lords.
You file detailed objections here also.
My lord, but the daughter has given a letter.
My lords, the letter is withdrawn.
We don't have it on our file.
Shown it to my learned friend that other day.
Give a copy.
I'll give her it. It has been withdrawn, my lords. My lords, these family disputes between, that's all it is. It all boils down to few considerations, my lords. That's all. She has withdrawn the letter, my lords. That is not the issue. Kindly see page 44, my lords. 44, this honorable court has issued a positive direction, my lords. Even there, the direction is positive.
Let them file objections.
Yes, my lords. From 2017, we going to improve the agricultural land. That's all, my lords. If the rocks are removed, we fill it with mud and we're going to use it for agriculture. That's all, my lords, we do. And that's why Rule 3A, my lords, provides for leveling of the land. It provides, my lords, for issuance of mineral dispatch permits without seeking for license or lease. I get what your lordships.
You can
mind-
get back the cost of the land also.
Yes,
While
my-
selling the Rocks.
Yes, my lords, but we pay the royalty. It
Correct.
is also paid, my lords. Royalty is also paid. Yes, my lords, I cannot deny on that part of it. They do make profit out of the rocks
Why
also.
such letters are being written?
My lord?
Why such letters are being written?
My lord, there's a dispute between the mother and the daughter. Daughter says, please don't entertain the application.
I have given my learned friend the letter.
Just
Letter.
now,
She
my
has
lord,
withdrawn it. The daughter has
just
withdrawn it.
now that letter is given, it is not there on a file.
It's okay. It's okay.
It's
My lords,
not
that
there on a
was
file.
that was between the mother and daughter because of
But you
some
could have come and filed a writ
some
petition
marriage
that,
issues between
no,
the
no, you
daughter
have
and
the
the mother.
authority to do so.
That is.
My lord, once that letter
So it was
coming before
withdrawn
my lord
immediately.
and saying that, my lord, they want an
My lords, let them not
permission.
convert it into personal this
No,
one. my
no,
lords.
you please don't exceed
tomorrow you
your
may
limits
write
with
letters
regard
to
to
No, my lords. No, my lords.
Tomorrow you'll.
My lords, it's
letters
not
to
the letter, my lords.
Why should
Let
I,
them.
my lord, mislead my lord?
Lords, there, I'm not misleading. I'm just saying, my lords,
That's what
what
you've done
happened? Why would I mislead? Why would I really mislead? I've never misled in 21 years of my practice.
So when shall we keep?
My lord, because I'll have to get detail,
21st.
my lord, tentatively, because I'll have to, tentatively, my lord, because I'll have to get,
21st.
yes.
Number 41. The Rajendras.
For the petitioner, my lord, the senior counsel engages on his legs in another court hall, my lord, says, the pass over.
My lord, appear for the respondent number 7.
Hold it. 41 is PIL, like.
Yes, my lord. My lord, the very same person has filed 7 petitions, my lord. All public interest litigations, KLR matters. That is not been disclosed.
Seven petitions.
7 petitions. Other petitions, the very same person in respect of.
Seek for a pass over, my lord.
Will grant time, provided you file 8 petitions in the meantime. It was submitted that the counsel who will appear to conduct on behalf of the petitioner has some personal difficulty. Stand over to.
My lord, may make one submission, my lord. The 7th respondent is running a educational institution on his own land.
There is no point in hearing since he's.
No, there is no interim order. What make me to
What date?
make this submission is, my lord, because of this petition, door number is not assigned. Educational institution, it has put up a 3-story building after obtaining license, permission.
On first, we'll take up first.
Please, please.
Number 42 is urgent. Number 43. The Somanna KP.
For petition. My lord.
Accommodation to get a endorsement to say that, my lord, the auction has not
Learned additional
held.
government advocate, Srimati Neelofer Akbar, stand over. It will go to 18th of June now.
Lords, a shorter date, my lords. I am ready with the arguments. My lords, may I point out one observation made by the Honorable Supreme Court, my lords. Just one observation, my lords. My lords, it is at page 78, my lords. 73, my lords. Lords, last paragraph, my lords. We have given a thought to the matter, and it is our view that the iron ore cannot be said to be the property of the Forest Department, nor can they lay a claim on the same. In view of the factual metrics of the case, the question, however, remains as to what has to be done with the iron ore mineral and powder on the basis of stand of the respondent, that this was the result of leveling of the land. Naturally, an inquiry would have to be made whether it was so. However, that would be a part of the task of the Mines and Mineral Department and not the Forest Department. My lords, they should have made an inquiry into this matter, my lords. Without making an inquiry, they have issued endorsement.
lords. Let's kindly come to the endorsement, my lords, which is at page 29, my lords. The Supreme Court has given direction 29, my lords. My lords, last but one para, my lords. As per the above said order, Forest Department has to hand over the Mineral to Mines and Geology Department to deal in accordance with law, and hence it is the property of the state government. As they have not inquired into the matter and they have already concluded that it is a property of the state government, my lords.
17th June.
That's a shorter date, my lord.
Shorter is given from 18 to 17.
44 is urgent, number 45, which is Sunil Kumar H.
Yes, Mr.
Appearing for petitioners.
Welcome
Raise
back.
for 1 week times.
Yes, what is it? PIL is there? PIL.
Kindly grant 1 week times. Some additional documents.
You came like a bang to argue the matter. Now you are seeking time.
1 week times.
Why?
Some additional documents.
No. This is enough document. Let us see what is contained in these documents presently available.
My lord, this pertains to rehabilitation of persons, my lord.
Probably you have to respond.
Yes, ma'am.
That's-
I haven't received instructions. Finally, my lord may have it 21st April. I'll try to see and.
So whom should we grant time, to you or to the council?
My lord, my lord, me.
Unless you answer, will not adjust. You should grant time to you or learned advocate, government advocate.
Ours 1 week time.
Up to whom? You are also requesting, she is also requesting. So to whom we should exceed? When we will file?
My lord, I need it 21st, my lord, make it.
21st.
Oblige.
Pledge.
Number 46, Ravindra Gajanan Kulle.
Yes.
Appearing for petitioner, my lords, requesting for a short accommodation.
All right. 19th June, as requested by learned advocate with the petitioner.
Grateful, my lords.
Number 47. Shilpa Rani.
As per last hearing date instruction, my learner friend have to make arrangement of my appointment, my lord. That is not made, my lord. They have made a submission in the writ petition, my lord, before the Kalburgi bench, my lord. They'll give a appointment in Bal counter affidavit filed by my learner friend on 27/2, my lord. Page number 4, my lord, para 9 says that, my lord. They have made a telephone communication to the Balki principal, my lord, since they also one more guest teacher is working. Hence, they are unable to give an appointment in Balki, my lord. They says they will give where the Bakkappa who filed the Kalburgi bench petition, my lord.
Some
Where
order was-
he came from the Kanpur, my lord. There will transfer. That is the, they have made a counter affidavit, my lord.
So respondents are directed not to relieve the petition.
My lord, a complaints affidavit filed on 27th February 2025, my lord, at annexure R4, my lord. Translated copy at page number 28, my lord. In 29, we have given in the Rani Chennamma Residential School, Kanpur Taluk, Basava Kalyana district, Bidar. Page number 28, my lord, that is the correspondent to letter issued to the complainant, my lord.
Impugned judgment, my lord, page number 15, my lord, serial number 11, petitioner is working before Moraji Desha Residential School, my lord, Ulsur Taluk, Bidar, my lord. That place has been disturbed now, my lord.
So what is your defense?
My lord, we have given the post.
Being under response number 3, and the direction is that not to relieve them
Please, my lord.
from that place.
For the reason, my lord,
No reason,
my lord,
whether you
May-
relieved or not.
my lord, last occasion we have made a submission before this court. There is one more writ petition filed by the permanent employee before the Kalburgi
Not
bench.
no any petition.
The Kalburgi bench,
Will stick to the directions of learned single judge in black and white and 4 corners of the direction.
my lord, we are not removing, my lord, we are taking the post, my lord, we are given the post, my lord. We are given the post already.
Where?
In page number 28, my lord.
Where you are given?
Page number 28, it's translated copy. In page number 29,
Yes.
29, in bottom, we are requesting you to join the post guest teacher to continue work. It is nearby residential school, Kittur Rani Chennamma Residential School at Basava Kalyana district, Bidar.
No, that's a total breach of the direction.
My lord, for the reason, my lord,
No, let
My-
let the person here.
kindly, my lord, kindly,
We can't rewrite the direction of learned single judge sitting in the contempt jurisdiction.
my lord,
You have to obey as it is.
my lord, my only
No
one,
argument, no.
my only one request, my lord,
Order
kindly,
of the court is order of the
my
court.
lord,
It is no color except black and white when the contempt court is concerned.
my lord, for the reason, my lord. we
Why
have-
you have sent him to Bidar from Bangalore?
No, not Bangalore, my lord.
Then
He is working in earlier, my lord, in the place of the Moraji Desai Residence School
wherever
at
they are,
Walsall.
wherever they are, you're supposed to continue and not to relieve them.
My lord, for the reason, my lord,
No
the
reason.
regular permanent
Cannot-
employee,
We are not going to listen to any.
for the reason, my lord, kindly,
reason.
my,
Only reason is the direction of learned single.
my lord, kindly,
We are not going to listen
may,
any reason.
may humble request, my lord, kindly, our response, R1, my lord, R1, annexure R1,
What is that R1?
R1, my lord, that is the official memorandum we have issued
Hmm.
to the one, the permanent employee
Hmm.
is transferred to his place, my lord. Subsequently, we have issued an endorsement.
No, we do not know anything. No attendance circumstance.
This order is challenged before the Kalburgi bench,
Let
my
the
lord,
person-
annexure
Let the person.
R2, my lord, kindly R2,
Are you going to cancel that?
my lord.
And whatever order is passed, relieving them should be cancelled.
My lord, we have cancelled. Subsequently, they have challenged that order, my lord.
We do not know.
Kindly, my lord,
What
kindly,
is-
kindly, my R2, my lord, kindly R2, page number 10.
Now, where you are working, madam?
I'm working in, my lord, page number 15, impugned judgment, my lord, serial number 11. Satish Shivaraj, he is a complainant, my lord, working in Moraji Desai Residential School, my lord, SC 353, Ulsur Taluk, Bidar district, my lord.
Now you are sent where?
Where one Bakkappa, my lord, he transferred to my place, sir.
Different school.
Please, my lord.
Different
So
school,
that
my
is
lord.
not permissible.
My,
Where one
that's the reason only, my lord, I make a submission.
need to
Are you ready to go there?
No, my lord. I'm a
That's the
guest
reason,
teacher,
my lord, I make a submission before this court, my lord. Kindly go to R2, my lord. R2, right? Page number 10.
Page number 10 of your,
Complaints affidavit.
yes, R2. Hmm. You are Satish.
Satish, please, man.
Satish Shivraj.
Please, man.
This, and direction number 3 is in tune with the direction.
You're working in Halsur.
Please, my lord.
So, by WP 313 of 22, you are directed to be continued over there
The
if
same.
you are not relieved.
Please, I have not relieved. I was working there, my lord.
Yes.
Later, after this order, my lord,
Then
one
two
Bakkappa came to my place.
20013 of 2025, you suffered an order where you contested the petition as respondent number 3,
Please, my lord.
and you were directed to be posted in Bhalki instead of Halsur.
He made a submission. Respondent number 2 made.
Whatever it is, you have suffered an order 13 of 2025, wherein you were directed to be posted in Bhalki instead of Halsur. Sir,
Please, my lord. By the Kalburgi bench, there is a direction, my lord. According
it's
to
High Court
their
of
submission-
Karnataka. It doesn't matter which bench.
Please, my lord, there is a direction to, according to their submission, since there is no vacancy, according to.
Have
their
you
submission-
suffered an order or not? Have you participated in the proceedings or not?
My lord, I have my argument also recorded, my lord, para number 6.
And you suffered an order that you had to be posted in Bhalki.
Please, my lord, they are not even posted to Balki also. Now they are posting me to Kanpur, my lord.
No, you said Baswa Kalyan.
No, my
Correct,
lord,
Baswa Kalyan.
Kanpur. They have transferred me, the order is there, my lord, their order only. They have transferred me to Kanpur, my lord, where the Bakkappa came, my lord. Bakkappa transferred from Kanpur to my place, my lord. Now they are telling me to go to Kanpur, my lord, which is 35 kilometers from my place, my lord. I'm a guest teacher, my lord. I'll get only 8,000 rupees salary, my lord. And one Bakkappa, my lord, getting 80,000 rupees salary, my lord. He is the permanent employee. And I'm working against the vacant post, my lord. Since from 2009, I'm working there, my lord. Page number 14, my lord, may I read? My argument is recorded, my lord. Para 6.
You just make it clear where you were posted at the time of impugned the order in contempt, where you are going to post it, and make your stand also clear, giving a synopsis.
Please, madam.
24th on 25th at 2:30.
Please, madam.
And we'll examine the effect of the subsequent one.
Number 40.
Direction issued by the complaint, the direction issued by the learning English.
Who appears for the complainant? Who is for the complainant?
For the complainant, my lord.
Yes, you copied to her. What you complied with? PDR certificate is to be issued.
Please, my lord.
Already
Issued, my lord.
My lord, I need to seek instructions. A week's time may be granted. I received the. This is 5th Feb of 2025, my lord.
English.
This is the verified to be listed at 2:30. You place by memo.
Please.
On the record to be listed at 2:30 on 25th of March.
Yes, sir.
Since it was so requested by learned advocate for the petitioner, who has received the copy of the transfer of development rights certificate.
Number 49. Mr. Sandeep Lahari.
9, my lords, I represent third respondent. That's request for 2 days time to file. Counter is ready, my lords. We just need, by Monday it will be filed, my lords. Reply.
27th.
Very well.
Number 50 is urgent. Number 51, Mr. Mahesh, yes. 51.
Respondent number. Who's number 1, my lord? After tomorrow, my lord. A little longer it may go, 29th of.
Number 52, Mr. Nitin Ramesh.
My lord, I appear for the complainant in this, my lord. The order for enforcement is a pension, my lord. The pension has not been settled still, my lord. It's been about a year since I retired. I went to the learned single bench, my lords, on the ground that when it came for deciding my pension, there was an endorsement issued saying that I am bound by the new pension scheme and they will not give me the old pension scheme. The learned single judge, my lords, has held that I am entitled to old pension scheme. And directions were issued, my lord.
30 years, my lord, served in the Raichur University as well as the Dharwad Agriculture University. My lord, he served, my lord, appointed by where direct recruitment. He served in this present accused number 1 university for a period of 5 years and all. The learned judge, my lord, directed the Raichur University to transfer the entire pensionary benefit to my university and settle the benefit. My lord, we wrote a letter to the Raichur. They transferred, my lord, 30 lakhs and all. That 30 lakhs, my lord, already been transferred to his account. My lord, for 5 years is concerned, my lord, I requested the complainant kindly furnish the PRAN number, my lord, for the last retirement where he retired. He required to submit, my lord, PRAN number. He has not submitted in spite of my request, my lord, PRAN number.
That is, may I complete my submission? There is no PRAN number, my lord.
That, my lord, 5 years I can calculate a old pension, my lord. It is, my lord, it is to be done at the government level as well as the Raichur. As far as accused number 1 is concerned, my lord, I have to pay the, my lord, his pension.
What is not submitted?
My lord, I am submitting, my lord, he served, my lord, the previous institution 30 years.
He did not submit what?
PRAN number, my lord. The teachers, my lord, they made, my lord, a new scheme to submit a PRAN number.
You must have that number.
No, he has to, my lord, apply to the concerned authority and obtain a
My lord,
PRAN number and submit to the university.
My lords, may I make a submission on this? This has been repeatedly said
please.
again and again, even before the learned single judge. My lords, there is no such direction.
file
My
it,
lords,
my lord.
even the issue of PRAN number is only when there is a new pension scheme. I am already told by the honorable single judge that I am entitled to old pension scheme. Anybody who is covered under the old pension scheme did not give any of these numbers. They are now introducing new conditionalities in order to enforce that order.
If that is so, my lord, they have to, my lord, approach the Raichur University and the state government.
Raichur, I am no longer an employee of Raichur.
No. I am, my lord, sought for a clarification, should be paid, we are ready to pay. 5 years I have to pay, I will pay it. No, subject to, my lord, he has to furnish the PRAN number. In the last week only, my lord, he amended the cost title, my lord, the earlier registrar name. Now they amended and present registrar, the counter is, my lord, ready. I will file it, my lord, within a
So the
week.
council appears to be read that he is to be treated under the old.
Please.
Old pension.
The old.
My lord, old pension only they calculated and my lord, transferred to me in turn.
Still, there is no requirement for getting any trans number or whatever.
There is no.
No, my lord, I will produce before your lordship, my lord. Any teacher retire, they require to, my lord, furnish the copy of the PRAN number. After that, my lord, we have to
reply.
The scheme is there, my lord.
1st of April.
First up, great.
Please.
Number 53. Sanchan Jay Nandan.
The endorsement has been issued, my lords. 17/3/2025, my lords, endorsement has been issued. The application, the representation made by the complainant has been considered. Sorry, my lord, I'm unable to give the translation copy. It was a direction in the writ petition that on the basis of another representation, it has to be disposed of within 3 months, my lords. Now on 17/3/25, Endorsement has been issued, my lords.
Please on record.
Please.
By memo.
Please, I'll file it.
Stand over to 25th of March
Please.
at 2:30. On which date? The counsel for the government shall produce a memo along with the endorsement.
Please, endorsement.
54, Mr. Keshav K.
For the complainant.
I am for the fourth respondent. I placed 2 weeks time for filing reply because it is benefits been short. The fourth respondent is not the regular director, he is in charge. So 2 weeks time I will file the reply.
24th April.
She may permit us to file the compliance affidavit. Paper be served as good. But as per the direction of this honorable court, below page 7, annexure R2, first endorsement. Kannada, English is below 9 as per the orders of this honorable court. But the direction is to consider his representation to enter his name in the Kata, e-Kata. But land had been sold to Karnataka Housing Board earlier by the original owner. So in this matter, we said that after a survey, we will
It is
consider.
complied with, Mr.
But seeking instruction, my lord.
No instruction. Why instruction?
Then second endorsement is 24 or 5.
As per
Final
the cooperative
endorsement.
direction
My lord, kindly pass over, my lord, start pass over.
contained in the order dated 11th June 24, passed by learned single judge while disposing of the writ petition. Comma. Petitioner was permitted to make one more representation to respond number
1.
3 authority, that's the Commissioner, City Municipal Council, Ramnagar District. Ramnagar.
I'll withdraw this, my lord, by seeking liberty to challenge the endorsement issued. And accordingly, my lord, maybe it's because they have now produced endorsement, which I'll challenge.
For change of khata in his name. When the contempt petition was filed in respect of the alleged non-compliance of the aforesaid direction, comma, in response thereto, comma, today, comma, learned senior advocate produces compliance affidavit along with which was produced endorsement dated 5/2/25. Representation of the petitioner. Copy thereof is given to learned advocate so and so for the petitioner. In view of the endorsement paragraph, learned advocate the petitioner seeks permission to withdraw the present contempt petition, seeking liberty to challenge the endorsement. Endorsement dated
5/2/2025.
5 or 5/2? 5/2/20. Seeking liberty to challenge the said. Such liberty is reserved. However, this court has not expressed any opinion on the merits of such recourse which may be taken.
Number 56, HR Shourie.
Yes.
In order, the respondent is supposed to conclude the inquiry which is against me, my lord, within a period of 8 weeks. It has not been complied. It has not been complied, my lord. The inquiry is supposed to be conducted or concluded within a period of 8 weeks. my lord.
The endowment Parishad.
Who appears?
In the writ petition, my lords, one Mr. Harish Chandra M has been represented.
24th March.
Please. Case number 57. K.V. Gangadharappa.
Nobody is present. 19th June.
58 urgent, seal number 59.
Tahsildar has not completed order of license surveyor and to secure body.
Lords, there is an observation that they have to make an online application. Lords, this is not a government land, this is a patta land, my lords. So therefore, they have to make an online application. Lordship may kindly see paragraph 8. Very clearly says they have to make an online application.
This contention
And I
is-
have ascertained from the ADLR's office that they have not made application, my lords. Once the application is made, Leveni sketch will be issued. Thereafter, my lords,
Learned AGA on instruction submits that the petitioner's request will be considered
this
if
contention-
physical application is made. You have made the physical application?
No, this contention is already considered by learned single judge. Kindly see page number 65. The lordships have specifically directed the Tahsildar to appoint the surveyor and to obtain body, my lords. Kindly see page number 65, my lords. May I just read, my lords, page number 65. For the reason stated supra, though this court is not inclined to interfere with the endorsement by the respondent number 2 Tahsildar, resolved the dispute by approaching a competent civil court, and the fact that there is a compromise decree drawn by a competent civil court, the respondent number 2 Tahsildar is bound to secure the division of the land in question through taluk surveyor or licensed surveyor unless body proceedings are concluded and subdivisions are assigned new survey number. The prayer sought in the representation calling upon the revenue authorities to effect changes in Kata appears to be premature. However, Tahsildar shall give effect to the compromise decree by concluding the ISSA proceedings. And my lordship's operative portion, my lords, the respondent number 2, Tahsildar, is hereby directed to appoint a taluk surveyor and licensed surveyor and secure body strictly adhering to the extent indicated in compromise decree drawn in number so and so.
This order.
Yes, my lords, I have given application. It is in annexure G, my lords. Page number 68. To appoint surveyor and secure body and further direct to issue fresh RTC exclusively in name of me as per order of Honorable High Court of Karnataka in WP number W22485 of 24.
Lords, they have made application to Tahsildar, my lords. This survey comes under ADLR. They have to make an online, there is a prescribed procedure. They have to make an online application to the
No, you agreed that if physical made, you will consider.
Lords, not to Tahsildar, my lords. Competent authorities, the ADLR with
An impediment,
prescribed
my lords,
fees.
if their lordships have observed that too. Here, my lords, as long as my name is not in RTC, I cannot apply. There is a circular to that effect. Kindly see that circular, my lords.
Application to competent authority.
Earlier, my lords, it has been rejected. The circular bars me from filing application.
Again, you made.
Tahsildar to appoint a surveyor.
No, Tahsildar will not appoint a surveyor, my lords. It is the
Specific direction is
ADLR.
that-
It's a patta land.
The specific direction itself is that, my lords, which is page number 66.
Maybe, my lords, but they have to make an application along
Why
with the
can't you comply with the order of the court?
Lords, may I make one submission? We have issued the
Notwithstanding
endorse.
any application is there or not. This itself is a mandate.
Lords, today I have ascertained the ADLR office does not have an application. It is not a government land, my lords. It's a patta land. The procedure for patta land is different. So it is as per the OS. Once they make an application to the ADLR, he'll appoint a surveyor. They have to make the prescribed fees.
No,
That
no,
is,
once the order is passed by the court, it doesn't know any procedure. Order is ordered to be complied with.
then let them at least make an application with the prescribed
No,
fees. my lords.
Nothing doing. When you are going to comply with. You can't fault the compliance of the order on the ground of application is not made, online is not made, signature is not made. This order is order. It comprehends everything. Every procedure is complete once the order is. And that is
I'll
the
take-
truth of the contempt jurisdiction.
4 weeks time, my lords. I will
No 4 weeks, 21st of April, all right, 4 weeks.
oblige.
Please.
To listed at 2:30, on which date the compliance will be acted upon by the.
My lords,
conduct
one
authorities
submission, my lords.
by appointing surveyor as directed by law and single judge, failing which a stern view will be taken.
Lords, one submission. At least let them comply, para 8, my lords.
What is it?
that is prescribed fees, let them make that one.
My lords, I have already stated that I am very much ready to pay that. In fact,
Yes,
it
let
is in
them pay,
already
my lords.
page number 69. I am very much ready, my lords. I have stated that.
Paragraph 8, my lords.
Page number 65.
Page 8, para 8 on 60, from 64 onwards.
The petitioner shall pay the prescribed fees for the
Plus,
purpose of
may I
appointment
read the full paragraph?
or within 1
May I
week.
just read just one paragraph?
1 week.
I have already stated, my lords, I am
Within
ready.
1 week.
They are not receiving it. That's the problem. I have stated, my lords,
Lords, it is online.
1 week.
I am ready to pay tomorrow itself, but they are not receiving, my lords. Direction may be given
They're
to
saying
Tahsil.
within 1 week.
Please, my lords.
Obliged.
Direction may be given to Tahsildar to receive
You
that,
have said it.
please. I am sorry, my lords, because they will come up.
Pay the prescribed
My lords,
fees.
no, I'm ready. I'm apologizing.
Obliged.
Yes, next.
So 60 is urgent, so number 61, Rohan Tiranathigidi.
Right, I appear for the petitioner, my lord, complainant. This, my lord, is a case of aggravated contempt, my lord. And notwithstanding several times this matter has come up before your lordships, they said they are trying to resolve it.
There is an order.
Absolutely no resolution.
While reading, I saw the order, if it is same matter.
8724.
General,
8724.
respondent, 87, yes.
Yes, they said it. We don't have a proposal, they've not told us what they're going to do, nothing. They are the ones who are violating the order. And today, my lord, they're filing a memo saying, we don't have land, we won't give it. Despite the order of the learned single judge
What is the
confirmed by the division bench.
Let us recollect what is the.
Yes, my lord. My lord, there was certain land to be acquired. I, my lord, was required to obtain consents and give it to them. They acquired the land. After which, my lord, they were to allot those lands to me. Instead of allotting the lands to me, they allotted it to someone else. Then, Lord, we challenged it before the learned single judge. Learned single judge holds that all the allotments made are contrary to the Industries Facilitation Act and have to be set aside. And that's the finding. We file a contempt before this court. They file writ appeal. In the writ appeal, on the ground that they want to challenge it in the Supreme Court. They went to Supreme Court rejected the SLP. Then, Lord, they come up before your lordship and say, the exact argument which was rejected by the single judge and division bench is the justification and contempt. Saying there's no land, we won't give it.
Very direction.
Yes, my lord.
Page 23.
Page 23, my lord, is the contempt order. At page 22, if my lord kindly sees, learned counsel for respondent accused submits that his page 22, my lord, 22. His client is preparing for challenging the order passed in writ appeal before Honorable Apex Court.
That is also dismissed.
Yes, that is also dismissed. SLP is dismissed. That my lord will find at page number 163. Then, Lord, I came back and filed a contempt after having waited for 6 weeks.
Now, where is that order? 11, 10, 22. Next.
Page 34, my lord.
Next. Page 13. Page 36.
Yes, ma'am. 36.
Start from 33.
In the result, this petition has made out a case for issuance of a writ of mandamus, seeking direction to the respondent KIDB to discharge his public duty. Accordingly, the question that arose for consideration of this petition is answered in favor of the petitioner. In the light of the observation made and subject to the direction given to our respondent KIDB, writ petition stands allowed. In the writ petition, Lord, the defense taken was, there are no lands available. We've already allocated the lands to various parties. That has been answered by the learned single judge at, my lord, page 34. Page 34, last 10 lines, my lord. The said government order. The said government order in unequivocal terms stipulates that the state committee granted 2 years' time to the petitioner to implement the project. In that view of the matter, making allotment to various persons as per Annexure R7 with the respondent KIDB, violating the resolution of the state committee as well as the government order dated 29 June 2020 is contrary to section 5. And therefore, I'm of the opinion that the petitioner herein has made out a case in its representation dated 21st January 2020, requesting the correspondent KDB to raise revised demand note in terms of the government order referred to above. Said representation having been made by the petitioner firm seeking redressal of its grievance in terms of the government order referred to above, respondent KIDB being an instrumentality of the state in Article 12, ought to have considered the same in accordance with law. In view of the inaction on the part of the respondent KIDB needs to be directed to consider the representation dated 21st January 22, produce the next record. Within 2 weeks from receipt of certified copy of the order, convey the outcome of the same to the petitioner. It is made clear that pursuant to the aforementioned government order dated 29 June 2020, petitioner has acted upon by entering into an agreement with the landowners and fortifies his legitimate expectation as enshrined in Article 14 of the Constitution from the respondent KDB to raise demand note as per government order. It is made clear, shall comply and consider the representation in accordance with the government order and the provisions contained in the Act. This, my lord, was challenged before your lordships, in the division bench, at, my lord, page 152, my lord. And the relevant portion, my lord, of the argument advance is at page number 160, point F. Please see the argument, my lord, and now the stand taken is almost identical. It's just identical. It is the same thing. Learned senior advocate appearing for the appellant KIADB contends that no land is available for being allotted to the respondent company, the same having already been made over to the other entrepreneurs. This aspect has already been considered and rejected by the learned single judge. We fail to understand the conduct of appellant KIDB in making allotments in respect to the land earmarked to the respondent company. The CEO of the KIDB ought to have notified such a development to the State High-Level Clearance Committee or Single Window Clearance Committee when the meeting was held on 23/3/2020. In not disclosing the allotments that were made or being made to others, he had kept the SSLCC in the darkness. That is the reason why the learned single judge found such allotments to be illegal. Allowing KIDB's appeal would virtually amount to placing premium on its illegal acts, and therefore a writ court cannot do it. Now,
But then if the plots,
there were industrial plots.
so not available, then what?
But that is why learned single judge says you must therefore take steps to cancel the allotment. Because you have acted, yes, that is the order of the learned single judge which this honorable court has accepted, despite the contention taken that there is no land available.
Where is that cancellation?
I beg your pardon, Lord?
Cancellation?
Yes, Lord. Learned single judge order.
Same order, 35?
Yes, 35. 34. That is a 34, Lord.
24. 24.
It starts at 24
Hmm.
and then, Lord, at 33. 33 is.
So that line of cancellation that they're directed within.
Yes, Lord. The finding at page 34, the said government order in the middle. Said government order in unequivocal terms stipulates that the state committee granted 2 years time to the petitioner to implement the project. In that view of the matter, making allotment to various persons as per R7 by the respondent KDB, violating the resolution of the state committee as well as the government order, is contrary to section 5 of the Act, and therefore I am of the opinion petitioner herein has made out a case in his representation to raise a demand note in terms of the government order referred to above. The said representation having been made by the petitioner firm seeking redressal of its grievance in terms of the government order, the respondent KDB being an instrumentality ought to have considered the same in accordance with law. Therefore, if all those allotments are illegal, the KDB has to take the necessary steps to give effect to it. I am to get that land. Then, Lord, what happened was when the matter came up before your lordships, they said we'll try and give them alternate land and we'll try and find a way to resolve this. We said, all right, if you are resolving it, tell us how you will resolve it. They said, you will find a way and resolve it. Which is why, my lord, when your lordships put it to us, I said resolution for it. No, nothing is given. The second the case goes out of the court's hands, it is forgotten completely. And there should be some value, my lord, to your lordship's order in contempt, saying 6 weeks' time is granted to comply. Nothing is done.
Is it consent acquisition?
Yes, consent the acquisition. I gave consents. I got the entire consent.
purchase
Yes,
of the
Lord.
land
All
for
the
the
consents were
purpose.
given. On that basis, they acquired.
Okay.
And then they did not raise a demand note. As your lordships know, they should raise a demand note. They don't raise a demand note. Then they try to alter the date and say, I'll raise a different demand note. That became an issue. Then, my lord, it went back to the State High-Level Clearance Committee. State High-Level Clearance Committee said, again, you must raise the same demand note. KIDB says, I won't. Though KIDB CEO, my lord, is a member of the State High-Level Clearance Committee, which is what the division man says. When you are present there, how did you not tell the State High-Level Clearance Committee? And then they come and say, we don't have land now. What can we do? That, my lord, is an argument which was considered by your lordships and rejected. It can't be a defense and a contempt.
Your silence is your answer.
Not like, and the Lord, we have allotted Lord to 165 Lord
We
entrepreneurs.
don't know, we don't know, we don't
That's-
want any argument in the contempt petition.
That's true.
We are repeatedly telling.
Please, my Lord.
Now
And
you
Lord,
come with the concrete thing, otherwise we are going to hold you up in the contempt.
kindly have the matter tomorrow, my Lord. Lord. Advocate General, my Lord, is held up in another court, my Lord, is arguing. Kindly have the matter tomorrow, my Lord. Will.
No, what tomorrow we'll do? Same wasting of time.
This land, my Lord, is not available, my Lord, to allot. This, my Lord, specific land is not available, my Lord. We have already allotted land. My Lord.
Whatever it is, you comply with the order to the satisfaction. If they are ready to accept other land, in fact, you suggested that, Learned Advocate General, and they gracefully agreed for it.
Lord, we said, if you come with something, I can at least look at it. You're not even telling me. It can't be a situation, Lord, you don't even tell me anything and let this linger as far as possible and then come and say again the same thing after 4 or 5 months, we'll come back and say the same thing. It can't be, Lord. This is completely inequitable conduct.
Of flouting the order, or disregarding the order, or shelving the orders of the court.
Not like that, my Lord. It's not possible to come. That
We
is,
call the person, that is the only, tomorrow Advocate General Learned Advocate may come, but with the Dr. Mahesh, the Executive Director of the Karnataka Industrial Areas Development.
I request tomorrow.
Along with respondent may, Advocate General may come.
Tomorrow, my Lord, will argue. Tomorrow, if necessary.
Learned Advocate Mr.
HL Pradeep Kumar.
states that tomorrow, respondent Dr. Mahesh M will remain present,
Not necessary.
along with Learned Advocate.
Lord,
Said it tomorrow.
Yes.
This is nothing to be laughed at
No,
when the court is making very serious comments.
yes, my Lord.
Bring him
Okay,
tomorrow.
please, my Lord.
Send out to tomorrow.
Great.
You come with the concrete thing.
Please.
Now we are not going to adjourn the contempt petitions for the sake of adjourning, because we have seen your laxity in several contempt matters, despite we taking a suo motu cognizance of non-compliance, and the order is now passed in that suo motu petition. Still, you authorities are not acting, responding to the court's order. Tomorrow, ask Learned Advocate General to be hearing tomorrow.
Please.
Yes.
Great.
Yes, madam.
62 is adjourned. Still number 63, Mr. MC Basuraj. Sanjeev here.
Yes. No, it's complied, madam. The order, I have also filed an affidavit, madam. Memo file saying that the salary has been paid for the 46 days as ordered by this honorable court. 46
And
days.
he has received the amount also.
Where is the petition? Learned Advocate Mr. Sanjeev stated that the order of learned single judge is complied with, and that the petitioner has also received the amount. Paragraph, since learned counsel for the petitioner is absent, to be listed at 2:30 on 25th of March.
64 is adjourned. Still number 65, Mr. Siddharth Suman. 65. Siddharth
65.
Suman.
No, nobody is present. 12th of June. None present, and out to 12th of June.
66 disposed. Still number 67, Sarita Kulkarni.
Yes. Madam,
Referred by BBMP, my lord. Vikram, legal senior counsel, is arguing, my lord. Seek a short accommodation.
on your behalf,
Yes,
16th of June.
obliged.
Number 68, Mr. Jaishankar T. Mr. Thomas T. MK, 14%.
My Lordship, my submission is all about illegal nursing education conducting at various nursing institutions in Karnataka with the silent support of Rajiv Gandhi University of Science. It is happening for the last 1 decade. Precious two nursing courses called post-basic BSc nursing courses and MSc nursing courses. The 2-year full-time courses.
We are not in the habit of boarding the bus in the middle. Start with the facts. We don't know what your matter is. We never board the bus in the middle. Start with the beginning, Mr. Part in person. If
Sir,
you
I
are well versed with
submitted
your case.
complaints before university to look into this matter.
What is this matter? Proceed.
Regarding this conduct of illegal nursing education.
Yes. Yes.
Page number 34.
State the facts.
4/10/2018, I submitted representation before University and Government of Karnataka Indian Nursing Council.
Regarding what we do not know
Regarding
anything about your matter.
Regarding
You
illegal.
give the facts first. State the facts. State the prayer. State the arguments and convince us. Your way of arguing will not convince us. The way we want, you argue.
My Lord, may I have a request, please?
Yes, please.
Can I have a date and can I take the assistance of a lawyer, please?
That is the best thing. That
Can
is
I have
the
a date, please? Can I have next date, please?
Yes.
One more date, please.
Learned part in person in course of the submission submits that he wants to take assistance of a lawyer. For that purpose, he 6 times, stand over to which date?
Next month.
Next month.
Yeah, or at your convenience.
Tell your date.
Maybe 10th or 12th of next month, April.
15th April.
'69. Mr. Vijay Kumar.
Those appear for the contesting respondent. I filed an application.
Yes, what is it about?
I filed an application to recall an order dated 2010-23. However, seniors on his legs. He is not able to appear. I request for a short accommodation. The order which I am seeking recall of Melods is passed despite the petition having already been disposed.
You are seeking recall of the order.
Recall Melods, this petition was disposed in the year 2022 itself. That order was not brought to the notice of this Honorable Court and an order was passed.
On which date?
Melods, on 5/9/22, this petition itself was disposed of, directing the Tahsildar to conduct survey. That survey has been conducted.
Then you have to file.
In my application, I produced all the documents, Melods, along with my application, recall application. At page 9 is the disposal order.
IA is filed. IA 1 of 23.
At page number 9 of my application, Melods, is the order of disposal of this petition. At page 13, Melods, is the operative portion.
We'll take up on some other day, right?
Please, please.
This is of 19th, so keep it on 16th of April.
Grateful.
You first.
Serial number 75.
The contesting respondents have been served and they have entered appearance. It was non-furnishing of PF. An acknowledgement of service has also been based on record, Your Lordship. It may be listed next week. There's an urgency in that matter, Your Lordship. Serial number 75.
75.
Yes, Your Lordship. The service may be considered complete because the copies,
Fresh matter.
it had come up before the court once, Your Lordship. Notice was issued, copies have been served and acknowledgement has been filed, Your Lordship.
2nd April.
Lord, serial number 74, my lord, there is an urgency in that the pledge of shares that, my lord, I have offered have now, my lord, is sought to be recalled, I mean, and invoked. And, my lord, there is a threat of dissipation of all of those shares, which is the entire shareholding of my group, my lord.
But in that somebody has made a statement, either of you. If it
Lord,
is
yes, that is so, my lord. They had said that no immediate steps would be taken in the sense that it will
Correct.
take
Lords,
some
I
time.
appear for the
But, my lord,
appellant in the same matter, my lords. It's my appeals which are also listed. The statement that was made on behalf of Axis trustee, that's the debenture holder, to the extent that until an order is passed and an appeal is filed, no action is being taken. As of now, an order has been passed by the commercial court and appeal has been filed before this honorable court. The same application was made challenging the invocation of the pledges. Those applications have been dismissed by the commercial court, against which an appeal has been filed before this honorable court. My submission is that in my appeals, an order was granted in my favor, permitting me to take appropriate action under that same debenture trust deed, which is what I have done, my lords. In fact, I have filed a section 7 as well.
That
I
has
have
to be
also
heard,
taken
then.
steps to invoke the pledge. I have not taken any steps to sell the shares as of now. The only submission that has been made is that if any steps are being taken to sell the shares, appropriate notice will have to be issued to the company. At the end of the day, these are all private companies, privately held shares, my lords. We cannot sell. It's not an open market
My
sale of
appeal,
shares.
if my learned friend says that there is not going to be any further, my lord, precipitation, I have no difficulty. But
My
otherwise,
lords, that is in essence granting the interim relief that they're seeking. That has to be heard. I've been granted
point is
permission by
that
this
that's
honorable
exactly
court to
what I'm
take
requesting,
appropriate
that I be
steps.
heard.
Today, whatever statement is operating, will operate till the next date.
My lords, no statement has been, no undertaking is filed before this honorable court. In fact, my lords, the only
your lordship
submission that
say
has
they
been
should
made
not
is
precipitate.
that
Please
if
keep
a
it
sale of
Monday
shares
close.
is
I will argue the
intended,
matter.
appropriate notice will be given.
You can't resile from the what was stated when it was taken up for the.
My lords, no statement was made. That was a writ petition. That writ petition itself is infructuous, my lords.
Grant the interim relief.
My lords, the petition has to be heard. Interim relief has been granted by this honorable court in my favor to allow me to take appropriate steps.
Correct.
My
After
lords, may
that, they
kindly
filed a
see the order
suit
of
in
9th
Bombay.
May
That suit is
2024 that
pending.
has been granted by this honorable court.
Learned friend should place all the facts. They file a suit, my lord, after this court granted permission in the
What was
vacation
interim
bench.
order? It is there.
My lords, it's 9th May 2024 and a subsequent order of 11th September 2024. My lords, by order of 9th May, what had happened, my lords, is a suit came to be filed before the commercial court at Bangalore, in which certain reliefs were sought, saying that all of the securities stand dissipated because there was no subscription of shares back in 2017. The suit is filed in 2024, my lords. In fact, I have also taken the contention that the debenture trust deed is subject to the exclusive jurisdiction of courts at Mumbai. I have taken
Please
that
look at this.
contention as
My
well in
learned
the
friend
suit.
takes the benefit of
My
orders
lords,
from your
thereafter,
lordship
the matter
and
was
then says
heard
no
before this
jurisdiction.
honorable court, and by an order of 9th May, if my lords has the order, if I may kindly point out, my lords.
So today we are not hearing the matter, but whatever is there, it continues. Interim order granted earlier shall continue to operate.
Please, my lords, that's the interim order in my favor, my lords. That's the order of 9th May.
No, but I
That
am
permits
no,
me to
no,
take
my
steps
learned
under the
friend,
DTD.
permit me, please.
There
I
is
am
no
making a
order in
submission.
favor of the appellant in 148 of 2025.
But
If my lords,
148 is my appeal. That is what I am mentioning. My learned friend intervened and then started arguing her appeal. My lord, my submission is this. Today, I am the plaintiff in the suit. The prayer is that the entire security stands discharged is my prayer.
Mr.
209.
Nand Kumar, any order is operating in your favor?
My lord, no, there is a statement made by them that there will be immediately nothing done, my lord. Of course, it is not recorded. It is an oral submission made. My lord, that now, my lord, what has happened is that the injunction application has been dismissed. I am now appealing against that. All I'm seeking is your lordship may accommodate me any short date. Till then, let me not precipitate. That's all I'm saying. Your lordship may keep it tomorrow, day after, any day.
These matters were taken up once before this bench.
No, my lords.
Lord, no. This
No, my
appeal
lords,
is coming up for the-
209, my lords, the main appeals, 209 of 2024, 165 and 167 of 2024 were heard in May of 2024, my lords. The interim order is granted in my favor in my appeals. Subsequently, what has happened, my lords, is after the interim order was granted in my favor, I have invoked those shares, my lords, which were given to me as security. Against that, applications were filed before the commercial court. Those applications were dismissed, in fact, my lords.
Against that, I'm
Against
on appeal
that,
before
now
law.
an appeal has been filed before this honorable court.
Who is the other counsel appearing?
My lord, my learned friend Mr. Srinivas Raghavan appears, Mr. Surya Narayana appears, my lord, for access trustee.
We'll take up on 25th. So
Great.
solve the
Till then, no
alternative.
precipitative steps. That's all I'm saying. Nothing
20.
else.
Sir, 25th is coming.
Please.
20.
Please, ma'am.
Grateful.
Lord, serial number 71. First petition has become infectious. Second, we want to withdraw and file a fresh petition because the final order is passed against the closing of action.
71, you are withdrawing.
Second petition, that 71 is
So I appear for petitioner in the first matter.
according to
71 is infectious.
My lords, your lordship, my lords, I appear for petitioner, my lords.
the main prayer is.
Yes, Mr.
I appear for petitioner in the first matter, my lords.
Yes.
My lords, in that, my lords, I have placed a memo along with a closure order passed by the Pollution Control Board, my lords. In fact, your lordship have directed, my lords, 1212 interim order, my lords, for closure. Accordingly, my lords, the board has passed a closure order. Only with the direction, my lords, to implement that order, my lords.
71.
Please.
Figures on the record of the petition. Memo dated 17/3/25, which reads as under. Quote the memo. In view of the above, the petition does not survive. As it has been rendered infectious, it is accordingly disposed of as having become infectious.
The second petition.
Interim orders, if any, stand vacated. All interim applications would not survive in
the earlier matter, not the.
disposal of the petition as above. Yes.
But in the earlier matter, lordship not.
71.1 you are withdrawing.
Second, 71.1.
Learned Advocate Mr. Desai Rajendra Chandrasekhar seeks permission to withdraw the present.
With liberty to file a fresh case.
Permission is granted. Why?
Closure order is filed. We had filed certain writ petition for a mandamus. No, that does not survive. In the meantime, an order is passed in terms of the memo that's filed by the petitioner.
You can challenge that closure order.
That's what, we want to challenge it. For that, liberty is required.
The withdrawal is on the ground that the closure order is filed. The withdrawal is permitted, dismissed as withdrawn. However, this withdrawal will not come in way of the petitioner to challenge the closure order in accordance with law and on its own merits. In respect to which this court, however, does not express any opinion on opinion. Yes.
Lord, serial number 70, my lord. Serial number 70.
17.
70, my lord, 70. Please.
Yes.
My lord, this is a matter in regard to violations of the CRZ regulations, the coastal regulation zone regulations. It is affecting the entire population over there. The state authority, my lord, has in fact submitted a report saying that there are violations that have taken place on 5th January 2023. That has been placed before this court with a memo, my lord. Subsequent to that, no steps are taken, resulting in these industries continuing to function in a coastal regulation zone area, which is extremely sensitive, which is causing very serious harm, my lord. The state itself has submitted that memo. In that memo, in the meetings, they specifically say that there are violations of the CRZ regulations. No steps are taken thereafter, my lord.
So what do you want?
My request is, my lord may have it on a short date so that they can take steps. And if my lords could direct them
17th.
if my lords could direct them to make a submission in respect of what steps they have taken thereafter.
17th April.
Serial number 85, 86, my lords.
86.
Commercial appeal against the rejection of my ex parte prayer in a section 9 application.
I appear for the respondent, my lords. I have only one submission. This is an ex parte order under. Sorry.
Yes.
No, same matter. I'm the respondent. Ex parte order in section 9 is under challenge, my lords. I have filed my wakalat before the trial court and filing my objections on 26th. Nothing survives in the appeal.
Difficulty is that the trial court, without any justification, has recorded a finding that the dispute is not arbitrable, which is why I have filed the appeal. It's come up in non-compliance because there's an office objection raised. I have made a counsel submission. They have said my prayer has to be more specific because I am appealing against the
office objection is dispensed with for the time being. The commercial appeal shall be listed on 2nd of April.
earliest possible.
Great.
Well, at serial number 88.
80.
88, my lords.
88.
This is a case where your lordship directed the University of Agricultural Sciences to implement the judgment. They passed an orders of regularization. Further, your lordship directed the government to give the approval, my lord. Last time, the government advocate took time. Matter has been sent to the finance department. They are awaiting. 3 times they took adjournment. If there is a not, my lord, by the department,
Who
appeals
appeals?
can be disposed of.
Who appeals? We'll take up on 16th of April.
Serial number 82.
Serial number 65, gone to 12, so the connected matter 27, kindly have it at 27.
27.
Serial number 82, my lord. In this case, I am to appear for respondent, my lord. In spite of your lordship direction, they are not complying the office of the
20.
After obtaining the stay.
Office options and orders are passed. They will comply with.
74.
Which one?
74.
Wherever it is there, it is.
Great.